Wait, please, your lordship. Lordship, with the consent of my friend lordship, item number 3, lordship, may after 2 weeks, lordship.
Item number 3.
3, lordship.
Gentlemen, there was, why this is for orders? What
Orders,
is it
lordship.
listed for?
Orders, lordship, because my lord has directed us to file affidavit, lordship.
Hmm.
That particular day, my brother is appeared, lordship, due to his medical emergency, he left for the court. After that, he missed the file, lordship. So, lordship, we own our part, lordship. It is not the default of the department, lordship. So, lordship, may 2 weeks time granted, we will do the needful.
What's your good name?
K. Gogoi, lordship.
K. Gogoi. Appearing for which department?
Higher education department, lordship.
Higher Education Department submits that he could not file the requisite affidavit and may be allowed 2 weeks further opportunity
Lordship.
to do the needful.
The date may kindly be fixed, my lord, and
Next on 7 June, the affidavit will be filed in the meantime.
Lord, oblige.
May please, your lordship. Item number 5, my lord. There is a small correction, my lord. May I be allowed to do the correction by hand, my lord?
Counsel for the petitioner pays for and is allowed to make correction in the memorandum, in the petition.
Petition, no, my lord. In the cost, my lord. Name, my lord.
What
Designation.
is the correction?
My lord, the respondent number 5 has been named as Deepankar Gogoi, the divisional railway manager. Instead of railway, it should be commercial, my lord.
It's permitted to make correction in the cost title of the petition.
By hand, my lord.
By hand.
5 and 7, my lord.
7 also.
Respondent number 5 and
All right, wherever you want your initial,
my lord.
mark your initials there.
Madam.
Make-
Oblige, your lordship.
Do you want to argue it today only?
Yes,
or
ma'am. Today, ma'am.
all?
All right.
Okay. This will be incorporated in the final order.
May I please, lordship? My lord, objection mention item number 15, my lord. By mistakenly, my lord, we could not have annexed, my lord, left out annexures, my lord. So we may be permitted to withdraw with a liberty.
Withdraw and counsel for the petitioner submits that inadvertently, certain relevant documents could not be annexed with the petition. He craves liberty of the court to withdraw the PIL petition and file a fresh with better particulars. The prayer so made is acceptable, hence the PIL is accepted, hence the PIL is disposed of as withdrawn, liberty to file fresh if required, if so advised.
May I please, your lordship, I beg to mention item number 12.
Hmm.
The engaged counsel for the petitioner is indisposed. The matter may kindly be adjourned for 2 weeks, your lordship.
It is stated that the arguing counsel, Mr.
And not.
Nath is unwell. Prayer is made to adjourn the matter. Rest of 2 weeks.
That's all right.
May I please, lordship, for item 24 and 25. This is income.
24 and 25.
These are income tax appeals by the department.
Hmm.
May I pray that may be taken up to 10 days, lordship, to obtain some certain instruction. I've also informed Mr.
Why you are shying away from arguing the matter?
No, lordship,
In the
lordship, no.
recent past, we have taken note of the fact that you are not ready to argue any of your appeals.
No, lordship.
No,
I'm very much eager to argue.
Mr. KL, praise for a short opportunity, prepare and argue the matters. List of 10 days.
My lord, 2 weeks.
2 weeks.
Oblige.
may I please, your lordship. I beg to mention item number 17, lordship.
Yes.
This matter may be adjourned for today, lordship.
Everyone, you have not filed any adjournment slip. Everyone is asking for an adjournment without making an advance request. This is really unfortunate. Counsel for the appellant pays for time to argue the matter. List of 4 weeks.
May it please your lordship, I beg to mention item number 26 of the daily list. Arguing counsel Mr. P.P. Das is out of station for his medical treatment, lordship.
Stated that arguing counsel Mr. Das is Ms. P.P. Das is not available today. Our request is made to adjourn the matter. List of 3 weeks.
Deeply obliged, lordship.
May it be please, your lordship. I beg to mention item number 23 of this list. This matter may be adjourned for the day. I need
Other side has no objection. Let's
I need 2 weeks times to file affidavit in reply
You are
for petitioner.
break for it is granted.
Great
2
appeal.
weeks time to file affidavit in reply. Please up to 2 weeks.
Obliged, your lordship.
May I please, your lordship. I beg to mention item number 19, my lord. I may be permitted to withdraw the
Counsel for the petitioner pays liberty to withdraw the petition, hence the same is disposed of as withdrawn.
much obliged.
May please, your lordship. Lordship, I beg to pray for listing of a matter. It's ready to be moved. It is challenged to a transfer order, my lord. By way of the transfer order, the petitioner has to effectively be demoted, my lord. Can it be taken up on Monday, my lord?
Give it. Let listen.
Obliged, my lord.
May I please, your lordship? Lordship, I beg to I want to pray for listing of an item on Monday. Lordship, in this matter, we have challenged clause 11 of the tender, notice inviting tender. Lordship, this matter was lastly listed on 18 January 2023 and notice was issued. Lordship, the settlement period is only for 1 year. So it
What
will,
happened in the meanwhile? What has happened in the intervening period?
Lordship,
It's
nothing
4
has
months.
happened. No, notice was issued on that date and Lordship, we are,
Thereafter, it has not been listed again.
no, Lordship.
Find out why it has not been listed.
Lordship, the matter may be listed on Monday.
Give the slip to the court master. We'll find out why it has not been listed.
Obliged.
Check the detail list.
Item number 1 of daily list for orders.
May it please your lordship. Lordship, the SLP is still pending. It was last listed on 8th of August 2019 before the appeal. Lordship.
It is stated that this SLP pending before Honorable Supreme Court has still not been decided
Lordship.
in view of the submissions were made. The consideration of this writ appeal is deferred by 8 weeks.
Lordship. Obliged, your lordship.
Item number 2.
May I please, your lordship, my lord. It was fixed for mediation, my lord, and the petitioner appeared, my lord, for the last petition, my lord. Also, it failed actually, it did not appear. It failed actually.
It failed. That's the report we have.
Yeah.
All right, now argue on merits.
Yes, only thing, my lord, here in this case, your honor. Here petitioner challenging the quantum, my lord. Quantum because under
Enhancement.
enhancement, under section 25, my lord, abruptly, suddenly, my lord, the court passed the order. My lord, that is my submission, my lord. And thing is, this, my lord, even judgment itself reflected, my lord, that regarding, my lord, he has got landed properties and all these things, my lord. You honor may kindly reflection in the judgment, my lord.
Any proposal by your client?
Lord, so far as the amount which has been fixed by the
3,50,000.
3,50,000, my lord,
Pretense, nothing.
that's true.
Then,
But if your lordships kindly turn to para 15 of the judgment,
yes.
when the learned family court came into, because the issue is, my lord, he is a daily wage earner, my lord. He lives in, he is a BPL card holder. He lives in.
BPL cards nowadays are available even with the government servants.
They are, my lord, and there is a finding by the learned family court that he is a BPL card holder and he is a daily wage earner, para 15, my lord.
He has paid the 3,50,000.
No, out of 3,50,000, my lord, initially he said he is unable to pay, but I had a talk with him, my lord, and I have advised him that you are bound to pay this amount because this has been fixed by the court. And of that, my lord, 1 lakh he had paid recently, my lord, and rest of the amount he is willing to pay, my lord. He has taken loan from somewhere, but he.
All right, then this has to be admitted. There is no way out then.
Lord.
LCR is received. The mediation proceedings undertaken between the parties failed. Thus, the appeal is admitted, sent for the LCR.
Highly obliged.
Respondent is represented, thus notice need not be issued.
Deeply.
All right.
Item number 4.
May it please your lord. In this matter, we are directed to take steps by Dusty and that has been done. We are filing the affidavit today, my lord.
You are filing the Dusty,
Yes, my lord. It has been Dusty.
Senior Counsel, Mr. Chaudhary submits. that the sea service has been affected on the response numbers
2, 3, 4 and 5.
2, 3, 4 and 5. He proposes to file the proof of service. Anyone is appearing on their behalf?
appearing for the public works department now.
Respond number?
2, 3, 4 and 5.
All right, so service, he is appearing. Mr. So and so puts in appearance on behalf of these respondents. The service is complete.
No.
What next, sir?
My lord, there are two other writ appeals against the same judgment.
All right, we'll
All
connect
three may
them.
come together, my lord.
This appeal along with the connected writ appeals, identical writ appeals number so and so shall be
128
listed together on, when do you want, sir?
Next week, my.
In the next week.
How less? Number with the Google.
Matter number 5,
That is your lordship.
Yes.
My lord, I think
Lordship, in this matter, Lordship, I have been asked to appear for the respondents, Lordship. Lordship will give me 10 days time. I'll file my.
You made a statement, Mr. Council, that there are few more developments.
yes, my lord.
What has happened?
We have filed an affidavit, my lord, at page 46, my lord.
Mm.
Now they have passed an speaking order,
They have passed in?
speaking order, my lord.
All right. So now what?
And now, my lord, there
The
is a.
speaking order would have to be challenged if you are not satisfied.
Yes, madam.
So then,
Here, madam, I am regarding the violation. I am on the violation, what they have done, madam. But there was a clear direction by this honorable court,
what is the direction? Let us see.
madam. Page number 27, madam,
27.
para 14.
Hmm.
Now, para 14 and 15, madam. Now, it's in madam, para 15, madam, it is been written, madam.
So opportunity of hearing and effective reasoned decision
Yes, madam.
that they have passed
But till then, madam.
till such decision is
Yes,
arrived,
madam.
appellants will be allowed to continue.
Yes, madam.
So your cases, they have not been allowed to
But,
continue.
but kindly see to the next page, madam, page 29.
Hmm.
No, sorry, madam, I'm sorry, madam. Page 37, madam.
Hmm.
This is the notice issued by the railway authority, madam, calling us as mandated by the Honorable Guwahati High Court in the above mentioned case. An opportunity of hearing is to be given to you. As such, you are requested to attend the office of the undersigned at 15.30 hours on 23.
23.
But, my lord, there, my lord, after the hearing, the speaking order was issued on the next day, my lord.
So
And here, madam, there is no clear indication whether they will be allowed to vend or not,
they will be allowed to vend.
vend or not.
So how do you establish the fact that you have not been allowed to vend?
But they are not allowed of.
Where is your government? Let us see.
Yes, madam.
The window was only of 10 days, sir.
My lord, yes,
10th March to 20th March.
yes, madam.
So where is your government that between 10th to 23rd, you are not allowed to vend?
Madam, I'm telling you, madam.
Let's read your
Now, para
petition.
4, madam, para 4, madam, page 48, madam.
Para
4, madam, of the original affidavit,
of your contempt petition.
madam, of the original affidavit, madam.
Yes, yes,
You have to make this out in your main contempt petition, sir. That you are not allowed to vend. You went there between 10th March
That was
to
after-
20th March.
Also, madam. Also, madam.
Read your pleadings, please.
Yes, madam.
Where have you narrated about the events between 10th to 20th?
Page 17.
Madam, at para 18 of the petition, madam, page 17. madam.
Read, please, read.
May I read, madam?
Hmm.
As the petitioner, we are not allowed to vend.
Mm.
As per the clear direction of the honorable court, surprisingly, on 17th,
Mm.
2023, the railway authority invited.
And now they have issued the letter for hearing.
Madam.
That was the direction given by this court. How is that a contempt? You don't say that you are not allowed to vend or you are obstructed from vending. Read, please.
Madam, there is, madam, it's there, madam. It's there.
Para 18,
May-
when did you go?
Madam, there,
Whom
but-
did you approach? This is a contempt
Madam,
petition.
these
There
are
has to
not-
be a
not-
strict proof.
Madam, respondent number 5, madam, the divisional,
Where have you mentioned, sir, that you went to the station You are obstructed, you are blocked.
Now, can you see, madam, thereby calling the petitioner to appear for hearing in the office of the chamber of the division commercial manager on so and so, without allowing the petitioner to vanish in the meantime, as per the order.
At the hearing, the petitioners requested to allow them. The next day, the order was passed.
Yes, ma'am.
So all right,
In a very hurry, manner, my lord. They are,
what is high-handed in this? They have acted
Ma'am.
with expedition. If you are not satisfied with the order, challenge it. Simple as that.
I will challenge, madam.
So how is it a
Yeah,
contempt, sir? What disobedience they have committed, willful? When did you go for vending? You were required to state it, that we went on such and such date with the order. You got a copy of the order on 13th as per yourself.
Yes, ma'am.
So till 13th, there was no question. Then when you went on what date with your goods and you were obstructed, where is the pleading?
We are pending there for last 40, 50 years, my lord. These are
Oh,
poor
we
people,
are
my lord.
not on the merits. We are on the aspect that in this short duration of 7 days,
My lord,
when were you obstructed?
that date, madam.
It's not there, sir. You challenge that order, that's the only way out. There is no willful disobedience as such.
My lord, evicting us forcefully after the order has been passed by the division bench of this court, my lord.
Gentlemen, where is the pleading?
But in the additional activity. we have-
Additional affidavit, all right, read please. Read. Let us see your additional affidavit. Page number
My lord, page number 48, my lord.
48, read.
Para three, my lord.
Mhm.
That this additional affidavit is filed to apprise this honorable court about the outcome of the hearing conducted on 23. By the railway in terms of the judgment and order that so and so, so and so. Hence, the petitioners have filed this contempt petition, and so after filing the said contempt petition, the petitioners were sub.
Sir, read from this. The only non-compliance or disobedience as per you now is that you are not allowed to vend in the intervening period.
Yes, madam.
Where is that?
But that is the course, madam. That is the madam grievance, madam.
So where is that pleading, sir? We are asking you. In this additional affidavit also, you don't say. You are making comments on the speaking order and the manner in which it was passed. All right, that can be examined, file a fresh writ. That's the only way out.
No, these are poor people, madam. They cannot approach the honorable high court.
Give them free services. That is it.
Madam,
That is the mandate.
So we have given them the advice, madam, but still they are not coming, madam.
Then they are not coming. That is their problem.
In para 16 also, madam, we have mentioned, madam.
No willful disobedience. Thank you. We'll give you liberty to challenge that order. Or you have already done it.
No, we have not done it, madam.
Then
We are
challenge
on
it.
the violation, madam, what they have done, madam. We are on the violation.
Sorry, what violation again? Thank you. Dismiss, no contempt. Notice discharged.
Item number 6,
May I please, your lord. My lord, in the IA, my lord, last occasion leave was provided, my lord, to implement the necessary party deputy secretary to the court or some.
You impleted.
Yes, respond.
Let's put them to notice. Interlocutory application number so and so has been filed for joining deputy secretary
Deputy secretary to the Gupta Assam Hill Areas Department.
so and so department. He is implemented as deputy secretary as respond number.
Respond number 8, my lord.
Where does your application say so?
Paragraph page 113 is my prayer. Ma'am.
But you have filed amended cost title or not? You are supposed to file an amended cost title. Also,
Yes, I'll file it, my lord.
all right,
After. this
we'll accept that application.
Yeah.
Interlocutory application filed by Clearance Council for the appellant to complete the deputy secretary so and so Hill Council is accepted. Amended cost title be furnished within 3 days.
Yes.
List thereafter.
Obligation, my lord.
item number 7,
May I plead your lordship?
Mm.
I have filed an IA for continuation of delay period. There are 52 days of delay.
Okay, yes.
There is a 42 days delay, my lord.
Hmm.
Order was passed on 15/2/2023, and a copy of the order received on 20/2/2023. Thereafter, the petitioner was informed, and at the relevant point of time, she could not decided that she will again file.
All right.
this.
Madam, what do you say?
Lordship, in case of delay, I have no objection.
All right, the connected rate appeal is delayed by 42 days.
Yes, ma'am.
Then counsel for the appellant as rate appellant has filed interlocutory application number so and so seeking condonation thereof. Then a common counsel MS Bora submits that she does not have any objection to the delay being condoned. Otherwise also, upon going through the grounds set out in the interlocutory application, we are satisfied that the delay is has been satisfactorily explained. Hence, the same is condoned. The application is allowed. Connected rate appeal shall be numbered and listed before the court
Where is my?
for admission.
Item number 8.
Yes,
We have filed an IA for substitution of the respondent number 2 and 35, my lord, who had in the meantime, my lord, expired.
passed away. For bringing on record their LRs.
They're legal IAs, my lord.
So what provision of law should the application be in? 110 or 22(4)? What should be the correct provision of law?
It should be 110, my lord. I would-
Are you sure? Is it substitution or is it bringing on record the alerts? Let us see.
110 is, yes, my lord. 110 essentially is, my lord, addition of necessary,
Addition of necessary parties.
my lord,
Then what is to be done?
my lord.
Hmm?
And the other issue, my lord, if 22 is applicable, when the question of limitation also comes in,
Yes, it would. That's why. That's why it becomes relevant.
my lord,
Then you also have to file an application under 22(5) also.
my lord.
So to avoid that, you have filed 110.
My lord, I have not stated any provision as such, my lord.
You have. That's why this question. Read.
Oh, my lord, oh, somebody has, my lord, typed it.
Somebody.
My lord, I did
Is it
not
under
notice
your
that.
signatures or
My
not?
lord, I did not notice that, my lord.
All right.
Because normally in writ proceedings, my lord, otherwise we don't cite, my lord, these provisions as such,
You are required to. There has to be some procedure by which particular act can be done.
my lord,
Anyhow,
my lord.
do you have any objection, madam?
No, Lordship, we don't have any objection.
An application number so and so has been filed on behalf of the appellant to bring on record the LRs of the deceased respondents number 3 and
2 and 35.
2 and 35. The notice of the application will go to the LRs. Notice of the interlocutory application be issued to the LRs sought to be pleaded. Steps be taken within 3 days, where a process be issued.
Ably approved.
Much obliged.
Item number 9.
May please. It is a
Yes.
matrimonial appeal minor. The father has been granted the custody of the minor daughter.
Mm.
That is 4 years, 5 months. Under Muslim law, minor, it is correct that the mother.
Mother is remarried. That is what the
Disqualified.
finding is.
Disqualified.
Mm.
But as per Muslim law, minor, if mother is disqualified, then mothers can be given. His mother is the party.
Can be given is a different thing.
But that is,
Then why the preference should not be given to the father if the father is available?
Muslim law says, my lord, otherwise.
Read which provision?
354, clause 354 is the disqualification of mother, and 353, right to female relations to in default of mother. Failing the mother, the custody of a boy under the age of 7 years and a girl who has not attained puberty belongs to the following female relatives in the order given below. Mothers, how high so
Where is this argument raised before the family court? Let's see.
No, my lord, that argument was not.
Was not raised.
It's not.
All right. Issue notice to the respondent. Steps for service be taken within 3 days, whereupon process be issued. records be summoned from the family court. Rule is Dasti service.
It can be.
Dasti service is permitted. Rule is made returnable. Issue notice of the appeal as well as the prayer for interim relief. IAS for interim relief.
Yes, my lord, the child already has been given to
So
the.
now there is no question of interim relief.
My lord.
The order is to be passed after hearing. Rule is made returnable on 13th June, list on 13th June.
Obligates.
Item number 10.
Well, this matter pertains to the running of a fishery, my lord.
Mm.
I'm partly agreed by the order, my lord, because my prayer for remission, my lord, has been directed to be considered, my lord, that I'm, my lord, not agreed.
Mm.
The part I'm agreed with, my lord, my settlement period has been curtailed, my lord. My lord, my settlement was.
Your
for-
last date, you made a mention that you want to bring on record certain.
Yes, ma'am. I have
additional
already
facts.
brought, my lord, some additional development that has taken place that I have filed an additional.
You
affidavit.
filed something. All
Yes,
right.
my lord, I filed it, my lord.
Additional affidavit.
Yes, ma'am.
All right.
Now, what has happened, my lord, here, my settlement was for a period of 7 years from the date of handing over of possession.
Mhm.
Now, that was in 2013, the order was passed.
Mhm.
But what happened, there were some litigations, my lord.
Mhm.
So almost 3 years is a pending.
Mhm.
After the litigations are over, my lord, I was given the settlement position in 2017. Now, from 17, my lord, 7 years, my lord, will be up to 2024, my lord.
Mhm. Mhm.
Now, my lord, that order was issued, but there was again subsequently cancelled.
Again litigation, a lot of
A
litigation.
lot of litigation. I'm not,
These parties seem to be very lawyer friendly, if we say.
my lord, because he was made to, my lord, file cases because of the situation that arose, my lord.
The lawyers are very proficient. How to
My lord-
increase the workload of the courts. Anyhow,
My lord,
Yes.
therefore, my lord, by this order, with the impugn order, my lord, my lord settlement was, my lord, curtailed up to, my lord, 2020, my lord. And the
20.
20, my
So
lord.
that period is long past.
No, my lord, since, my lord, there was an interim order pending, my lord.
Hmm.
The order, my lord, was passed in 2023, my lord. during
So
the
you have
tenure-
already enjoyed for 6 years.
6 years, no, not, my lord, we have enjoyed for four years in fact.
Why your original order was,
2013
position was given in 2017. we suppose.
17, my lord. So we.
17 to
yes.
2023.
23 we continued,
Six.
but there are other issues because, my lord, we are not allowed to operate because of, my lord, certain additional settlements within the fishery made by the government, my lord. That is why the prayer for remission came, my lord.
All
Now,
right,
here,
we'll
my lord-
issue notice,
My lord, that is not.
issue notice heard, issue notice to the respondents. Appearance, who will be appearing for the respondents, please specify. MS Bhattacharya puts in appearance on behalf of the respondents numbers 1 to 10. Mr. Chaudhary,
Referral 14.
Mr. M.K. Chaudhary, senior advocate, puts in appearance on behalf of the respondent number 14. Mr. So and so, your good name, please. B. Chaudhary puts in appearance on behalf of the respondents numbers 11 and 12. So all respondents are covered.
No, 13, my lord. 13, my lord, one is the missing autonomous council, my lord. Oh, well,
You are for 13.
so all are covered, my lord.
So all the respondents are thus duly represented and hence notice need not be issued. List for final disposal
My lord,
in July,
my lord. Deeply obliged, your lordship.
is final disposal at the admission stage
My lord, deeply obliged.
in July. What is the IA?
My lord, IA, my lord, was for, my lord, stay, my lord.
No ground is made out to
My lord, I'm not pressing that at
pass.
this moment. Let me-
Ms.
let me heard.
Bhatta does not press the interlocutory application. Hence the same is disposed of as not pressed.
Right.
Fresh
Then am I-
settlement has been made or not in the meantime?
Pardon, my lord?
There must have been a fresh settlement in the
Well,
meantime.
My lord, no, daily settlement has been made, my lord. And I will show, my lord, that has been made at a lower price, my lord, which was, even then, what I was paying, my lord.
Direction has been given to make a fresh settlement within 3 months.
Now, a temporary.
And
arrangement
the
will be-
defaulter, my lord, of about 60 lakhs, he has been directed to file a representative.
That also I've done, my lord.
All
Those are pending, my lord.
Okay.
Deeply obliged, my lord.
Item number 11.
Okay, there are certain orders of the Honorable Court Lordship, Supreme Court Lordship. Pertaining to notification of the employment through the employment exchange law. They were calling through employment exchange law.
What is the controversy in brief, please?
Lordship controversies, Lordship, NRL, Lordship, Numoligar Refinery Limited, Lordship, are calling candidates through the employment, local employment exchange only, Lordship,
All right.
and not through other sources.
for giving employment therein, Lordship. So Lordship, I have challenged that, Lordship. I live as, we people live elsewhere, not in the district of Golaghat. And we are being deprived from appearing there, Lordship.
So they are doing it under a particular set of rules,
Set of rules, Lordship. that I
which
have
are under
challenged.
challenge.
There is another challenge,
Which are the rules?
Lordship.
48, madam.
Page 48.
48. Relevant is page 49, clause 7, rule 7.
Are these statutory rules?
Madam,
Are these
these are-
rules statutory rules?
No, but this is a.
Then why it comes to division bench?
Because, my lord, what had happened, they had filed this here, because this is our policy. We recruit under this. My lord will remember, on the last, my lord will just have 49, 7.11. That my.
No, we understand.
Oh, there's
Question
no-
is,
Lordship.
these are not statutory rules.
Lordship, no.
Why do you need to come to division bench?
Lordship, I came before the single bench, Lordship. But
You filed it before single bench.
Lordship, it was filed before the single bench. Then it was sent to the division bench, Lordship.
My lord will remember that case. This matter was argued before my lord, wherein my lord, the local employment exchange, we say local employment exchange. Then I had brought before my lord the employment exchange rules.
1960,
Lordship, wherein the, my lord, employment exchange is, it's there before my lord.
defined.
Wherein, my lord, the definition of local employment exchange is given.
Hmm.
And the local employment exchange is the exchange which has jurisdiction over the area where the organization is situated.
All right.
So, my lord,
So
we,
this provision is not under challenge.
no, no, that my
Lordship-
lord wanted on the last occasion that they put it to challenge, my lord.
Lordship, may I see, Lordship, the Honorable Supreme Court's order, Lordship. Therein it says, Lordship, may I first come to the writ application, Lordship, page 55, Lordship. Notification of vacancies to employment exchanges, Lordship, page 55.
Yes.
So, Lordship, they have given it, Lordship, after the commencement of.
The rules they have also annexed.
Lordship, last number, Lordship, 4, Lordship. Nothing in subsection 1 and 2 shall be deemed to impose any obligation.
So it's not an obligation,
Lordship.
but they have chosen to do so.
Lordship, but that has been barred by the Supreme Court, Lordship.
Let's see.
Let's see.
That is given, huh?
2010, 11 assistant, 674. Lordship, may I come to page 17 and paragraph 17 and 18 of the Lordship, 2010, 11 SCC, Supreme Court, Union of India and others versus Pritilal Nanda. Lordship, 17 says the requirement of notifying the vacancies to the employment exchange is embodied in the Employment Exchanges Compulsory Notification of Vacancies Act 1959. For short 1959 Act, but there is nothing in the Act which obligates the employer to appoint only those who are sponsored by the employment exchanges. Section 4 of 1959 Act, which provides for notification of vacancies to employment exchanges, reads as under. That has been given lots of notifications of vacancies that I have already pointed out, Lordship. And 18 says, Lordship. May I go to 18? Those. Lordship, 18 says, our reading of the plain language of section 4 makes it clear that even though the employee is required to notify the vacancies to the employment exchanges, it is not obliged to recruit only those who are sponsored by the employment exchanges. And next, below Lordship, 18, there's a 6 sub number, Lordship. It is therefore clear that the object of the Act is not to restrict, but to enlarge the field of choice so that the employer may choose the best and the most effective and to provide an opportunity to the worker to have his claim for appointment.
Mr. Nair, your action seems to be questionable in view of these judgments.
My lord, I'll explain that. Here, my lord, it's not that all the vacancies that arise in our organization, my lord, we are putting it through the employment exchange. It's only those category 4 and category 5 posts, which, my lord,
Why you restrict to the local exchange?
because, my lord,
Give opportunity to others.
because, my lord, therein we have enough pool. A pool is there, my lord. So moment the rule also provides, my lord. It's not that We don't get it, we will not, we'll wait for somebody to arise there. The rule also provides that it is open for us to go to selection from the open market when a non-availability certificate is given by the employment exchange.
That's what his issue is.
Lordship,
Why wait for this non-availability certificate? Circulate it to all
no,
employment.
we do
exchanges.
it for all other posts, my lord. It's only for these
Why,
categories.
why this
Because, my
distinction?
lord, two
What
things,
is his justification in this distinction?
the justification, my lord, as per my understanding, is that, say, my lord, we have one post, we get hundreds, my lord, from there only.
Maybe leave it open, let everyone apply.
My lord, for the, because this was a recruitment, my lord, done in a, this is a, my lord, that accord, this, my lord, refinery. Now, wherein, my lord, this situated, we had taken lands there. And for that entire area, my lord, because of this, other
You
activities
had made
cannot
an
be done.
agreement with the locals.
Not the locals, my lord.
Yeah.
It's an agreement made so that, my lord, the people therein
Get
have
employment.
an employment, because other things cannot happen. So for a limited number of posts, we have kept this, my lord. Whereas for all other posts, we have all India advertisements. my lord.
All right, you file your reply
I'll do
affidavit.
that, my lord.
All right. Then Council, Mr. Bhagat, is placed reliance on joint and urges that the restriction created by the so and so rules, that rules being adopted by the respondent in as much as only candidates sponsored from the local employment exchange are being allowed to participate in the selection for grade 4 posts.
Grade
Grade 4, 5, 6, 7.
Grade
And so on.
4, 5.
Lower category post.
Lower category.
Lower category posts,
Large number of
posts
are there also.
below grade 4 and other categories is illegal, arbitrary and unconstitutional. Issue notice, Mr. Nair puts in appearance on behalf of
My lord, the respondent number 4, 5 and 6.
4, 5 and 6, who appears for 1 and 2. S. Boda, Mr. S. Boda puts in appearance on behalf of the respondent numbers 1 and 2. 1 only. Who would come in for the others?
I'll be for 7 also, my lord.
For 7 also.
My lord,
that's-
respondent number 3 and
2, Principal Secretary, Industry and Commerce.
Mr. A. Kolita, my lord, my lord.
Mr. A. Kalita puts in appearance for the spot number 2 on behalf of the spot number 2. 3, you are coming. 3 and 8, Ms. M. Bhattacharjee. Thus, service is complete. Council for the petition to supply copy of the writ petition to Land Council representing the respondents who pray for and are granted 4 weeks' time to file affidavit in opposition.
Much obliged.
Number 13.
There are 2 judgments he has relied upon.
There are 3 judgments.
3 judgments.
May please your lordship. This PIL has been filed by the petitioners on the challenging action of the authority by whereby their village, the village, entire village people has been included into
Town
town
committee.
committee. My lord, they are earlier, they are falling under the Kaupanchayat and being rural poor.
Sir, this
They
is
are getting
the,
some benefits which will
this
not
is,
be given.
this is the result of urbanization.
My lord.
Can anyone avoid this? This is happening everywhere. The towns limits expand.
My
They have to encroach into the villages. There's no way out.
My lord, in the event of that, my lord, as a rural port, they are getting some government benefit.
Understood,
And that
sir.
will be curtailed. And
That is right. But for that reason, can we curtail the boundaries of the towns to expand?
my lord,
Everywhere, the municipal areas, the areas of the autonomous
my lord,
institutions.
that has been done, my lord, without giving any opportunity to raise objection, my lord. That is also there.
Is it necessary?
Yes, my lord, the section 5 of the Assam Municipal Act
All right,
1956.
issue notice to the respondents. Steps for service be taken in 3 days, whereupon process be issued. Rule is made returnable in so and so. Deeply obliged, Lordship.
Number 14.
Lordship, this is a matter pertaining to
construction, ongoing construction of a flyover, Lordship. This has been filed in the form of a PIL by a public spirited person. Lordship, this has been. The work is going on. This public spirited person wants the work of a flyover to be stopped.
Because it is violating the Assam financial rules, Lordship. This is an ongoing flyover, ongoing construction, but then
Yes.
it was started before any tender was issued, Lordship.
You yourself say that in reply to the RTI, you have been informed that there was a short-term tender.
Yes, Lordship, only after 10 months, after 30% of the work has already been done.
Tender was issued thereafter.
Yes, Lordship.
Issue notice. Who would be appearing?
Report 3 and 6.
Mr. So-and-so puts an appearance on behalf of the response numbers 3 and
Lordship,
6.
Lordship, there is an interim prayer that.
No, we'll not stop the work. No question. There is no question. One stay would delay the project by years together. We have seen that time and again.
But only till this new tender
Absolutely no, sir.
process is completed, Lordship.
Big no. The work was started long back. You yourself say 30% is complete.
Yes, Lord.
So no question of stay. Mr. Who would be representing the other respondents, please? Roads, PWD. 1, 2, 4 and 5. Mr. So-and-so appears. 6, executive engineer, PWD.
3 and 6, I mean.
3 and 6. And 7, Karbi Anglong. You will also appear for 7. Is not a part of the council. Number 7,
7 is the NS division, my lord. NS division.
NS division.
NS division not under.
All right. Puts in appearance, so the service is complete. Council for the petition to supply copies of the writ petition to the current council representing the respondents who may file affidavit on behalf of such respondent, affidavits on behalf of such respondents within next 4 weeks, list after 4 weeks.
Item number 16.
Yes.
My
Have
lord,
you read the judgment of Alka Oja?
that I have seen, my lord.
Yes.
My lord,
5 years they had worked.
my lord, other aspects are there. I'm taking, let me take your lordship to page number 89 for a moment to the conditions of the advertisement. Your lordship will find Hindi teacher in graduate scale. Page number 89. Hindi teacher in graduate scale. Probeen oblique Ratno in Hindi with 50% marks having degree qualification from any recognized university.
Yes, the
Or-
50%, yes.
Or BA with Hindi as one of the subjects with 50% marks.
And not B.Ed,
And B.Ed.
not or. It's or it's and
B.Ed. So-
not or.
I have got B.Ed.
Makes
my
a
lord.
huge difference.
Yes, here my lord lordship find BA Hindi with one of the subjects with 50% marks.
Yeah.
That I had.
50%,
Marks-
not only in Hindi. It has to be aggregate.
That is the issue.
But the authorities. my lord,
50% is in the degree, not the subject.
My lord, the authorities have understood like that way, my lord. And as a result, my lord,
They granted you wrongfully, granted you the selection.
if my lord, the 50%.
How can 50% qualify a single subject? Let us know. Degree and 50%, they have to be. The subject is just one of the essential parts which you have to have. But the degree is supposed to be with 50% marks. Supposing there is a candidate
Yes.
who has around about 36% marks only, and he has 50% in the optional subject. Would he be qualifying? Not at all, sir. We are talking of teachers. They want a certain benchmark.
Yes, in the
You don't have that benchmark.
in the
You are getting that benchmark in the post graduation would not make any difference. That is your next argument. The learned single judge has taken care of it, saying that you will get your opportunity in the next recruitment because the rules have been changed in 2018. That's all.
my lord, I will humbly submit, my lord, he has been appointed otherwise also. my lord.
Read Alka Oja, 5 years.
That I have seen, my lord. That I have seen. And even without notice, my lord, I have been,
Notice is not required. There was a case of wrongful appointment without to a person not qualified to hold the post. Okay, thank you. Dismissed. This will come into the date. Issue. You have to file. What is the file? Actually, they- it's a detail. Please type it.
Item number 18.
This statement takes care of it. These were more transport, sub-inspector, or appointed without having the notice. Yes.
May please, your lordship. This is a writ appeal, my lord, directed against the order, my lord. The lordship will find at page 81 for a moment.
This, Rupam, we have decided one matter wherein the inspector was given charge of the headmaster because the headmasters were not having the qualification.
Yeah.
Yes.
My
Now,
lord,
what do you say, sir?
My contention before the single judge is that, my lord, whether seniority of a teacher is to be counted from the date of initial appointment or from the date of acquiring the requisite qualification, my lord. And that's the case, my lord. I rely upon my lord judgment, my lord. That has been, although that has been referred, my lord, it has not discussed, my lord. If your lordship turns to page 6 for a moment, my lord.
Yes.
Page 6 of my writ appeal, my lord.
Yes.
I have given a comparative statement, my lord. My
Yes.
appellant petitioner, date of birth, my lord, lordship has seen, my lord. Qualification is also same, my lord.
How the learned single judge has dealt with this argument?
My lord, that was not referred, my lord. In fact, my lord, it was referred to the, my lord, the authority to decide the seniority. And in fact, my lord, the state
So
respondent.
let them decide.
No.
In case you are able to satisfy
My lord,
that you have the 10 years experience,
my lord.
you will be able to lay a claim for the post.
But the state respondent had filed an affidavit, my lord. But already my case was rejected, my lord.
So you challenge that rejection, that is the way out.
By way of affidavit, they have stated, my lord.
So challenge that rejection by a fresh writ
In
petition.
that case, my lordship, will approach the, my lord, authority, my lord. within a
All right,
time
then
frame.
counsel for the petitioner frankly concedes that as the respondents have indicated in their affidavit that claim of the petitioner for seniority.
Yes.
On the basis of qualification from the date of entry
Acquiring-
into service,
And acquiring the requisite qualification.
date of acquiring the requisite qualification has been rejected by the respondents. The petitioner would be better advised to approach the authorities with a representation so as to ventilate her grievances.
Man,
He craves liberty to withdraw the writ appeal with the above liberty to the appellant.
man, I'm
And counsel, Mr. So and so has no objection to this submission. Thus, the writ appeal is disposed of as withdrawn with the liberty prayed for.
I'm obliged.
Item number 20.
May it please your lordship. Lordship, on the last occasion, there was a direction to file affidavit by the state respondent lordship, which would be required.
Yes.
Otherwise, matter pertains to misappropriation of a fund.
Lordship, we have received the affidavit filed by the respondent number 4. We rely on that affidavit only.
All right. They rely on respondent number 4's affidavit. Argue then. Ready?
Lordship.
All right.
Your lordship may come to page number 22, the audit report submitted by the state authority itself,
22.
page 22.
Mr. Counsel, the allegations are serious. Are you sure that you will rely upon the respondent number 4's affidavit? All right. Page 22.
Page 22, para 2 lordships. Down below the page. Non-remittance of admission fees, tuition fees to the government. In scrutiny of the records revealed that an amount of rupees 16,72,003 only were collected from the student as admission fees, tuition fees during the period from 1/4/2027 to 31/3/2012. But the same was not remitted to the government.
This is the audit report or what?
This is part of audit report, my lord. It starts
Audit
from
report.
Audit report, my lord.
Yes. How they have responded to this? What is the response of the state authorities to this?
Lordship, state has not filed affidavit yet.
What has respondent number 4 said to this? Let us see. What has the respondent number 4 said about this? petitioner himself was a member of the governing body for 2014 to 18. No objection raised. No bona fides of the petitioner are in question.
Lordship, the fund was not related to period 2014 to 18, Lordship.
Maybe when did it come to your notice?
Lordship, I have obtained this information by way of an RTA information, Lordship.
When?
Lordship. It was furnished on 17/12/2020, my lord.
Now read para 10 of the reply affidavit of respondent 4. Governing body of the college being the highest decision-making body within the college, and every member of the students have right to take up the issues. But this is not a very, you are for respondent 4. This is a flimsy explanation. All right, we call upon the government to give the affidavit. How can you rely upon a private respondent's affidavit? What kind of irresponsible stand is this? Yes, read.
There is no misappropriation. Lordship, second paragraph. He skipped.
On account of absence of instruction from the higher authority which caused loss of government revenue.
No, my lord, no, page 22, my lord.
Read.
No, this is the non-remittance of admission or tuition fee to the government. Second paragraph, it was seen, this is the audio, it was seen. The college authority spent the amount for various miscellaneous.
This is a very vague observation, Mr. Counsel.
No, ma, this is the report.
This is a very vague observation in the report. With this observation, the last line is that this has caused loss to the government revenue. Admission fees has to be remitted to the college, to the government. How it was not done?
Lordship, but I'm.
All right, we direct investigation by SOG. What do you say?
Lordship, other thing is there, my lord, because this petition is targeted and object of this petition and target of this petition is.
Let the affidavit of government come.
Lordship,
The
6, my lord.
let the affidavit come.
Lordship.
The learned counsel representing so is directed to respondents numbers 1, 2, and 3 is directed to file affidavit on behalf of such respondents within next 10 days.
Oblige the Lordship.
Lordship, I am raising the maintainability of this.
We'll see. Let their affidavit come.
Lordship.
Oblige the Lordship.
List on 6 June.
Lordship, can it be after 15th of June, Lordship?
After 15 June. Then let it come in 3rd week of July.
Oblige the Lordship.
Granted 4 weeks time to file affidavit list after summer break.
Oblige.
The number 21 and 22.
Recovery.
Lordship, this is an appeal filed by the Fishery Development Corporation, Lordship. We are agreed by the learned single judge order. whereby
Directing payment.
To make the payment during the inquiry. And finally, the inquiry is complete, Lordship. All are illegal appointees. Even at that point of time, all it was open and shut case, Lordship. If Lordship is pleased to look at one of
What have you done against the officers who have given the
Yes,
illegal?
Lordship. They are all under
appointments?
suspension. Arrest is, sanction is awaiting. They were all suspended on 9th of February 2023.
Okay.
And these people will also get arrested, Lordship.
Okay.
They all have the money in their personal account of fishery departments. Very lot of the very unbelievable things happened here.
All right. State what do you want to say?
So regarding this impugned order, Lordship, we are agreed.
The learned has held that the
Because at that point
appointments
of time,
were
the
illegal.
inquiry was not completed. If Lordship is pleased to come to page 100.
Para which?
Para 9.
Para 9, yes, read.
However, in view of the fact that the petitioners have not been paid their salaries since November 2021, it is expected that the inquiry report should be concluded within a specific period and preferably within a period of 3 months from today. Report of the inquiry headed by the Additional Chief Secretary Fisheries should thereafter be communicated to the respondent who shall thereafter make an immediate decision with regard to the stand of the 2 and 3. Here, Lordship, we are agreed by this order on 2 accounts. At that point, a departmental inquiry was going on. Now the CID inquiry is going on. And during this time, the learned single judge directed that we should.
You are reading this order is No, this is not the impure order you are reading. You are reading from some other order, 25/3/2022. Or is this is the interim order, impure order,
Impugn order, Lordship will find that. Page
30th March
27 onwards,
22.
page 31.
Yes. What is the grievance against that order?
From such viewpoint, we direct the authorities in the respondent AFDC to pay the salary of the petitioners till such time the enquiries are conducted against the petitioners are brought to their logical end. It is further clarified that any enquiry or proceedings that may be initiated against the petitioners may be brought to its logical end, and any observations made in this order shall have no effect in such enquiry or proceedings.
Okay.
So our case is that at that point of time, the enquiry was going on. They were given so cause notice to substantiate their claim that they are regular entrant to the corporation. That stage, Lordship, we have stopped the salary also.
Could
The
you have
reason
done
being
it
very-
without concluding the inquiry? Why?
Yes,
Were you-
Lordship, because from our side, there was no post, no advertisement.
Then you
no
could have
recruitment
terminated them
policy.
outside at the outright without holding an inquiry. But once you start an inquiry,
That enquiry was just to fulfill the requirement of the principle of natural justice.
understand?
But once
You
certain
understand?
situations.
You could have put a condition that you are being paid, but it will be liable to be recovered.
Yes, now Lordship, the thing is, the Supreme Court is very clear. If they do not have a legal right, because if Lordship is pleased to look at their appointment order, there is no mention about any selection.
We are not on that. That is in your domain. You hold the inquiry past that order. That is when single judge has also said. Question here is, assuming that they were irregularly appointed. And
I
you have
fully
taken
agree.
work from them.
Why we have done the enquiry? We know in our home, there was no selection process, no interview, no advertisement, nothing. All of a sudden, at the instance of few persons who are at the helm of affairs, they inducted this huge number of employees on officiating basis. And they started paying money. And the salary is also quite high.
Okay.
Now, when we have come to know that these illegalities has taken place, and there is absolutely no doubt about that from our side, but to fulfill the requirement of the principle of natural justice, we have given them an opportunity. This inquiry was nothing else but to give them an
Conclude the inquiry
opportunity.
within 10 days, 15 days.
It was done, Lordship. It was at the very earliest possible time we have done it. And once the inquiry was completed, Lordship, we have immediately lost the case in CID. The main officers were all under suspension. Arrest is imminent against them. We are not arresting them because the sanction is awaited under 197 of the CRPC. Now, even if, Lordship, suppose they now satisfy this honorable court that they have entered the service to a legally permissible scheme of public employment, we are going to give, Lordship. They do not, there are only cases that their appointment order, if Lordship is pleased to look at only one appointment order.
Let us see that. Let us see.
Page 63. Page 63. May I read it?
Yes.
They have also taken the name of the Honorable High Court. In the interest of public service and in pursuant to the directions given by the Board of Directors of AFDC Limited, held on 28/9/2020, followed by the order issued by the Honorable Chief Minister Assam, and considering the vast experience, good service record, and honoring the order passed by the Honorable Guwahati High Court, and as per the record of selection committee constituted with the chairmanship of Additional Chief Secretary, Fishery Department, Government of Assam, followed by the records of screening committee, AFDC, and verifying the records of outstanding service performance of good integrity through confidential report of screening committee of Sri Spandan Das, working as contractual fixed salaried employee since 2019 against the existing vacant post in the office of AFDC Limited, is pleased to pass order to officiate Sri Spandan Das as junior administrative assistant in the scale of pay 14,000 to 60,500 with grade pay 6,200 in pay band.
They've been put in pay scale by
Yes,
this order.
Lordship.
Really.
And
That
plus
man,
other
the man
usual-
has guts.
They
That
have
we can
guts.
say.
And if Lordship is now in the inquiry, it has come to our notice. If Lordship is pleased to look at the signature of MD, and there's a small signature side. His name is Spandan, and he's a writ petitioner himself. Very startling facts.
This has the approval of the chairperson AFDC. Who was the chairperson?
Lordship, I do not want to take their names, Lordship.
No, but what has come in inquiry? Has the
He has been
chairperson-
removed from the chairperson
Is
of
the- is-
AFDC.
Was there
He
a
is-
noting? No, yeah. Was there a noting of his approval?
All these records are with CID, Lordship. All these records are seized.
No, but this
A very big,
order
huge
passed by
scam
the
had taken
Guwahati High
place.
Court. Which was the order of Guwahati High Court?
I do not know, Lordship. Let them produce it.
Yes, Mr. Kanwar.
My lord, your lordship will kindly see the copy of the FIR which has been filed. We have brought it on.
Forget
record.
about that, sir. Look at your appointment order.
Yes, I have.
Which is
seen.
the Guwahati High Court's order?
My lord, the order to, I don't have the order of the Guwahati High Court, which has been referred in the order. In the appointment order, but your lordship will see.
But they are taking
My lord, this
advantage of,
my lord, your
taking advantage of an order of this court which never exists. That by itself is a ground to terminate.
That also I cannot say, my lord.
Your
but
client's
lordship will
signature,
see.
Yes. Mr. Kanwar.
Yes.
Your client has signed this order. In what capacity?
No. He's
Yes.
This is not the
Are you
signed by
sure?
the managing director, my lord. I think this is the receipt copy. Receipt copy because we have annexed this order.
No.
They have not annexed. This is our document, my lord. Only
Yes.
on when the order was received, he must have signed it to receive the copy of the order. Your lordship will see, even this order has been marked to the OSD, to the Honorable Chief Minister of Assam and all the officers. Now, what has come out in the inquiry, they have not annexed the inquiry report. But they have filed an FIR. We have obtained a certified copy of the FIR, and the certified copy of the FIR includes the observation made in the inquiry. Your lordship will find in our additional affidavit. the
Why do
copy
you
of
want
the
this court to give an imprimatur to the inquiry report? You
No,
give
no,
your clients the
But,
liberty to
and
contest.
what has transpired, madam, how this has occurred, madam, that is referred in the inquiry report. Your lordship will see. We are not to be blamed, madam. Your lordship will see page 114 of the.
Not to be blamed. You are the employees who are working on
Yes, madam,
temporary
they have a-
basis, and you have been given pay scale without any cause.
Madam, your lordship will see that is there. The board of directors have taken their resolution. It's not.
They are
one man.
all facing the music now.
No, only, madam, they have only against the chairman and the managing director. The board of directors is not under the scanner. Your
Board
lordship will
of
kindly-
directors, this
Your
order
lordship will
doesn't.
kindly see for a moment the observation made in the inquiry report
Not a-
at page 114, paragraph number 7, madam.
140 or
114,
114.
madam. Nowadays, madam, it is a running page, so it will be 114.
Yes, read.
It is pertinent to state herein that there was a provision in the original memorandum and article association of AFDC Limited that the corporation can engage person temporarily through fresh recruitment or re-engage retired person on lump sum pay. But in case such monthly remuneration exceeds rupees 15,000, it is mandatory to obtain prior approval of government. But it is learned that such provision empowering government to interfere in affairs of the corporate as well as prior approval for engagement exceeding rupees 15,000 in the original memorandum and article of association have been repeatedly amended by AFDC without the knowledge of government may look into it. So AFDC by their board of directors have got doing all these things, madam. We have our simple claim is that you have extended our service, pay us, will go. Then whatever the logical conclusion of the law will take, we'll face it. But when you have utilized our services, we are not, first we have to show that we are party to this illegality. Well, where is the evidence that we are party to this illegality? Your lordship will see the inquiry report from page 109, the initial, my lord. 109, the inquiry report starts, my lord, and the scope of inquiry, your lordship will find at page 111. And paragraph 6 at again at page 114, your lordship will find it is seen that proposal for such illegal appointments have the approval of the board of directors from time to time in 2020 and 2021. The committee is of the view that while the board of directors has the power to decide fill up regular vacant posts following established rule and procedure, it is incumbent upon the managing director to ensure that such appointments are made as per established rules, procedure, and neither the board nor the chairman and MD back out the responsibility as provided in the rule on the plea that such proposal has the proposed approval of the board since any such. But if these persons have done such illegal act and they don't take any action, there is not a single whisper in this inquiry report attributing any illegality on a part that we are party to this fraud or illegal or irregularity which has occurred in the board. Let them show one statement attributing to us in this inquiry report that we have taken part in that illegality, or there was some a money transaction to show. My lord. My lord, let them, what I would propose today, my lord, let them file an affidavit, what action they have taken against those officers and the board of directors.
Read page 113. That
Yes.
we'll ask them, don't worry.
Yes,
Read
ma'am.
page 113, just above, between E and 3. Read.
The said appointees were from a
No,
location
no.
near an
113, 113 between 2E and para 3 at the bottom.
Yeah.
In none of the above scenarios.
In some cases asked directly to official and right. In none of the above scenario, and at some, none of the stages where any post advertised by AFDC in either their website, that we are only temporary employees. my lord.
Continue. How it was done, the entire thing smacks of a conspiracy.
No, my lord, the entire,
200
my lord,
people
these
taken in this
officers,
manner.
my lord, if your lordships on the next date, if they come up with an affidavit saying that they are taking action against all these
All right.
officers and all, then
You
we
file an
will see,
affidavit,
my
what
lord.
action you have taken
Yes.
against the members of the board?
In
Members of the
fact,
board-
in fact, I have challenged the learned single judge order because no opportunity was given us to file affidavit.
Is that so?
Yes, Lordship. So if Lordship may remand it back to the learned single judge.
All right,
we
yes,
file
what do you
detailed
say to
affidavit.
this?
Naturally, the-
Hearing them,
Instead of.
I can file
sending
here
remanded-
also, but I would like.
They can
not
file
want
it
to
here. They have
use
already
one forum.
They have only to bring it on record, what action they have taken against this
No, we
officer.
do not.
we'll stay the effective operation and give them the opportunity. All right.
Even they are not paying, in spite of there being a contempt petition, they are not paying.
Heard learned counsel
they
for
know.
the learned advocate general representing the appellant and Mr. Kamar representing the respondents. This appeal is directed against, the intercourt appeal is directed against the order dated 27th June 2022 passed by learned single bench in WPC number so and so, whereby the appellant APDC have been directed to pay the salary of the writ petitioners within bracket respondents till the conclusion of the inquiry initiated on the acceptability of their appointments. Then Advocate General submits that the appellant was not provided an opportunity of filing its affidavit in the writ petition. He further states that many of the officials involved in the appointment of the appellants have been placed under suspension. An FIR has also been registered against the illegal appointments, and that the matter is now pending for grant of sanction to prosecute such officials. In view of the submissions noted above, in view of the objection raised by Mr. Kamar, we hereby direct learned advocate general to file an affidavit as to whether any, to satisfy the court as to whether any action is sought to be taken against the members of the board who were
Including the managing director and the chairman. Ma'am.
the managing director, the chairman, and the other members of the board
And the
of
officers
the
who are-
corporation,
Officers who are responsible for giving the appointment. order.
as and so also the officers
Fair enough.
responsible for the grant of appointment to the respondents. In the meantime, effect and operation of the direction given by the learned single bench to pay salary to the respondents till the conclusion of inquiry is stayed.
Highly obliged.
List on
2 weeks time may be given.
7th June.
Highly obliged.
And petition also will go after 2 weeks, after, will come upon 7th June. Yes.
Deeply versed.
Item number 27.
Yes,
So Lordship may kindly see the last order, my lord, dated, my lord, 4/4/23, my lord.
that's what, yes.
Last order, my lord, passed by your lordship, 4/4/23, my lord. Well, the government advocate shall take instruction.
Yes,
Lordship, we have taken instruction, Lordship, and the deputy commissioner has stated that there was no vacancy in other department during that time.
you file this on affidavit.
Lordship.
Then Common Council Ms. M. Bhattacharjee submits that she shall be bringing on record the instructions received by her, received as a pursuance, in pursuance of the direction given by this court on 4/4/2023 through an affidavit. It will be done within 10 days list. after 10 days.
I'm aware.
Deeply obliged.
Item number 28.
May I please your lordship, in this case, I need to some more time to take instruction, lordship.
MS Bora prays for and is granted further opportunity of 4 weeks to complete her instructions. Interim order passed earlier shall continue. List after 4 weeks.
Item number 29 to 41, part heard matters.
These are arising out of NI two. I have started this judgment and I will leak it that NI two will start. Yes. Which are the appeals arising out of NIA two? Can anyone please indicate? Only two. Criminal appeal 305/7. And Vanlal Channa. The Vanlal Channas, there are 2 appeals. Probably no. Mohit Hosai, I suppose.
I'm just.
Jivangshu Pal. Jivangshu Pal is at criminal appeal 252. There are only 2 appeals of 257/17. Yes.
257 and 305.
Okay. Yes.
Let me be a good listener today.
Is anyone, Gunaji, is anyone taking now the arguments I told on the first day? Is anyone doing that? Has they been typed out? No.
At least your lordship can take the help like what is happening in Supreme Court now. The live proceeding, you're getting at all the transcripts. If someone can do that, it will be very beneficial, my lord. Transcript.
Tell Mr. Burman, yes. बाद में मुझे ध्यान नहीं रहा. Yes.
Lordship. The appeal, here in Lordship, there are, I would say, 3 sets of accused. Niranjan Hojai, Joel Garlosa, Lordship.
Direct, the main actors.
Main actors.
Main actors as per you, yes.
Then
they are the Amitabh Bachchan and Shatrughan Sinha.
And
yes.
And, along with Vallal Chana supplier, and rest are all Lordship.
No, you forget one link in between. You see, these are the main actors. For them, the procurement is done by Joel Garlosa, right? Then through Mohit Hojai, and this procured amount is routed through Vanlal Channa for getting the arms. That is your case in sum and substance. In between, there are peripheral agencies. These Jibang, these Devojit and those who are small time players.
But summing
Wealthmen sort of things.
Summing up, they become big.
Yes.
Now, Lordship will consider first.
And how will you brand Imdad Ali? In which category should Imdad Ali have been?
Lordship,
That is also. Now, Lordship, let us first see.
You know, on record, Imdad Ali had the highest amount in his accounts. And there was no investigation. There's nothing at all. And if your evidence is to be accepted, he was into the thick of the things. Okay.
I, Lordship, will not go beyond the what is there.
Yes.
Now, Lordship, let me first start with Niranjan Hoja and Joel Garlosa.
Yes, yes, yes. What evidence?
Niranjan Hoja, Joel Garlosa, Lordship, submission has been made that they are, they could not have been linked to the DHDJ. That is one aspect of the
So
matter.
on what evidence do you propose to link them?
I-
Let us satisfy.
I will, and I'll place some other material also, Lordship. Only one material which is not a part of this case.
Which
but-
can't be read. There is no
Lordship,
question in a
because
criminal
that is
case.
That is something Lordship can read. I will place that.
If it is a judgment, well, that's a different thing.
I will place that.
Yes.
Hey. Lordship, the star witness, Lordship, PW 24.
24. We need someone to assist us. Find his 161 statement, please.
My lord, we have.
I've got it. I've got it.
Let us have a copy.
It is in other case.
29, my lord. We
It
have
is
got.
in the other case.
We'll need to read that.
PW 24.
PW 24.
Oh, Lordship, can I read this 161? Lordship, I have it.
We'll read it. You argue as you want. It has been exhibited in NIA too.
No, my lord.
Not exhibited.
No. What happened is that, my lord, in as far as Amitabh Sinha is concerned, your lordship was correct that the learned trial court has accorded that there is certain two or line improvement in an impugned judgment. Amitabh Sinha was, when R.S. Khan cross-examined him, he said that I have not stated this fact and that person was quoted. And Pojendra also did the same thing. But in the, when the Mukesh Singh was investigated, my lord, evidence was recorded, nothing of that sort has come up. Prosecution did not contradict or corroborated anything. The learned trial court in the impugned judgment has accorded that yes, there are certain improvements, but still it can be inference can be taken up. That is what.
All right. Yes.
Lordship, PW 24, Lordship will find at page 81.
Yes.
What does he say? Lordship will note. I'm just reading it. I joined in March 2009 as additional SP headquarter. So he was additional SP headquarter NC Hills, not Kachar Hills. I continued up to December 2010. NC Hills is presently known as Dima Hasao. At NC Hills, I was responsible for maintenance of law and order and crime detection in the area. Immediately after my joining, there was a spurt of violence because of DHDJ. There was Naga and Dimasa ethnic clashes.
Yes.
DHDJ has stopped the train services plying from Lamding to Bodhapur, thus virtually stopping the food grains, not only to Barak Valley, but also to states like Mizoram, Tripura, and Manipur. DHDJ would resort to firing on the moving train from the hills on both sides of more than 120 kilometers railway track. This was the situation when I joined. Because of counterinsurgency CI operation, lots of additional forces were deployed. Things gradually improved, finally leading to laying down of arms by DHD cadres in March, April 2010. But there was always a feeling and apprehension and some intelligence inputs as well that all arms and ammunition of DHDJ were not handed over at the time of laying down arms. On 8/7/2010, now this first paragraph, Lordship, is under objection because they say it was not stated in 161. I'll come to that.
And
On 8/7/2000,
bereft of that objection, what evidence does it give? That he has a perception. Has he narrated any particular incident? Or any corroborative material to support that train was stopped? It's a very huge incident. Which is the report?
Lordship,
Which is the report? Tell us.
no particular report has been
Then-
referred to here, Lordship. Lordship, let me proceed.
Hmm.
On 8/7/2010, we received specific information that a consignment of arms and ammunition were kept hidden in a jungle. After verifying this information that there was some authenticity in the input that we received, I, on the instructions of SP Dima Asal, conducted a search at Disa Kisan area. I was accompanied by OC Haflong, a large number of forces. Thereafter, on search, we could find several gunny bags, some behind rocks and some concealed with earth. And on opening the sacks, we found a large number of sophisticated weapons, which included AK-47s, M16 pistols, lithoid guns, as well as M21 rifles. We found that these were indeed highly sophisticated factory-made weapons. There was no question of witnesses as there was no habitation in the area and it was dense jungle. But in presence of police witnesses, the arms were seized. Thereafter, I informed the SP about the recovery and I was instructed to take all the weapons back to headquarters. On returning back to Haflong, the officer in charge, Haflong PS, lodged the FIR and the case was registered as 54 of 2010. The original copy of the FIR would be in the case record. Exhibit 57 is the photocopy format of the FIR, so and so, under objection as it was a photocopy and he is not the maker of the document. Exhibit 59, photocopy of the Caesar list containing 44 numbers of weapon and 41 assorted magazines and shells. This is also under objection. Exhibit 60 is the photocopy of letter dated 16/7/2010 addressed to the SP NIA, New Delhi camp at Guwahati, annexing FIR and Caesar list. Exhibit 61 is the signature. 61 is the photocopy of the letter dated 3/9/2010 addressed to the SP NIA, New Delhi camp at Guwahati, informing regarding the status of Umrangso case number 6 of 2001 and Umrangso PS case 18. I have informed that both these cases were charge sheeted against Fonen Naiding and Hangwon Hasnu, both DHD cadets. In the second case, 18 of 2000, Arnold Fanglo, Modest so and so, Biren Singh, Langthasa, Than Sun, Than Janan, Hafila are all DHD cadets. Now in the cross.
Gentlemen, what do you want the court to believe from his chief? First tell us that. Forget the cross. There was no cross examination.
Lordship.
What do you want the court to extract from this statement?
Lordship, the first paragraph
Yes.
of his statement that he gives before this honorable court. Lordship,
That is an ipsi dixit. He doesn't narrate any incident. It's a general newspaper
Yes.
kind of thing.
yes, Lordship,
There is news in the air that these things have happened.
Lordship, let me.
What kind of inference can be drawn from that?
Lordship,
Then
he was the additional SP of.
maybe he
of
may have
that.
been the DGP. We don't care. What has he said, sir, which the court is to rely upon?
Lordship will kindly, Lordship will just bear this in mind. Let me go to the other PWs. Lordship will see.
Right now, you are asking the court
Yes.
to believe on this witness. We
Lordship,
want to know what is the substantive evidence he has stated.
What?
Please read section 60 first. Section 60 of the Evidence Act. Whether this part of the evidence should have been allowed to be recorded. Read 60.
oral evidence must in all cases whatever be direct.
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 So direct means what the witness has seen, he deposes in the court.
Yeah.
Does your witness say that I saw any of these events other than that recovery of weapons? We'll come to that later.
Lordship, let us.
So the first para is just a general information he has received. Second para is relating weapons 8/7/2010.
Lord,
Now a simple question, just hold on. Niranjan and Joel Garlosa were in custody when this recovery was made. How do you link them? Assuming that he has proved the recovery for a moment, how do you link them with this?
Lordship.
And one more thing, sir. In his entire testimony, he has not uttered a single name like Joel Garlosa or Niranjan Ojai.
Lordship,
Now you can proceed.
that will not keep them away from the DHD. I am coming to that.
All right. You've got the membership forms with you.
Lordship,
You've proved the membership forms.
they say before the court, Lordship. They have come before the court stating that they are the chairman, they are the commander in chief.
Yes.
That is what I will please.
Oh, yes. Oh, yes. Wonderful.
That Lordship can see.
Yes, yes. yes,
Respect
yes.
our interim bills, my lord.
Now, Lordship, I would take your Lordship to the evidence of PW.
What have you have completed the Samhitab Sinha. Nothing more to say. What do we have to infer from his evidence? Tell us about this case.
Lordship, what he says in the second part is recovery of some weapons, which
Which what?
yes, Lordship. In the cross of Lordship, page 83,
Yes.
cross of accused Joel Garlosa and Niranjan Hujai.
Hmm.
As per the information received by my higher authorities, we planned an operation. I am not sure. Before moving to the place for search and seizure, whether any GD entry was made or not, I have not given one statement. I have given one statement, but I am not sure whether it was recorded in the NIA special case 1 or NIA special case 2. That is in the other case, Lordship, that statement. As the area where the search and seizure were made is completely a dense forest and different militant groups generally operate because of the land topography covered by the dense forest, it is true that there were two groups, DSDN and DSDJ, and DSDN was in ceasefire. We did not seal the packet, the alleged seizure at the place of alleged, it's come twice. At the alleged, at the place of alleged seizure.
What was the fate of those weapons? What was the fate of the case registered after recovery of those weapons, please? Let us know.
Those were handed over. No. What? Huh? What? No, this. You come here.
एक हिंदी में एक मुहावरा है, जमीन निकल गई है आसमान खा गया।
नहीं, आसमान तो नहीं खाया होगा।
बताइए कहाँ गए, हमने समझना है कहाँ गए,
हाँ।
क्या हुआ उनका? What happened?
Not in this Lordship, this weapons is in the other case, Lordship.
Other means what?
The
Other means what?
It's in the state case, Lordship. Lordship, let me clarify. There is an FIR lodged with regard to the alleged seizure of arms and ammunition, and investigation is going on at present. I am not aware of the present status of the case.
Meaning thereby, Mr. Chaudhary, you have provided no evidence to show that that recovery is even remotely linked to any of the accused in this case. So this is just an extraneous piece of information he has given us. There is not even an allegation, not even an averment that those weapons are in any manner concerned with DSDJ. Your witness doesn't say. So his evidence is just
Lordship will
a worthless piece of paper.
Lordship will come to the last sentence, Lordship.
on cross-examination.
Yes,
It is wrong to say. All right, when has he said?
Lordship.
When has he said that they are of DSDJ? So that he is made to answer, it is wrong to say.
Lordship. That
He has not even said so.
I
So
cannot
that,
go beyond.
again, that cross-examination is also irrelevant. Because he has not said so in his chief.
Let me take your Lordship to the,
And what about this improvement? What is your call on that?
im-
This entire part which is stated in first para of
in the
his
first
statement.
paragraph, Lordship, I would not, in my humble submission, it is not a matter of contradiction. Rather, I would say, I would submit, Lordship.
This is not a contradiction.
I would submit, Lordship, it's a matter of omission because he was the SP of that place.
Oh. It is an improvement which fact the witnesses admitted. The trial court somehow or the other reads only the last two lines. But the witness admits the entire improvement. The entire first para of witnesses.
Lordship,
I
listen,
did not
I
say,
did not say.
I did not say. So
He said.
he did not say means it is not there in the first statement.
Lordship.
All right. And what is the effect of improvement? We'll consider.
Lordship.
All right.
I take your Lordship to the evidence of PW 72. 72 to what?
Page.
Page 465.
What is the name?
Anurag Tankha.
Tankha. Yes.
465.
Volume 2, volume 2. 465?
Lordship.
Yes, please come.
Lordship.
Yes.
Today I have appeared before the court on receipt of summons from the court. In the month of June 2009, I was posted as SP of police, NC Hills Haflong. I remained there as SP Haflong up to February 2010. So far I remember, I received a letter dated 6/6/2009 from DIG NIA, New Delhi, RP Meena, seeking some information in respect of ongoing investigation. I replied to the aforesaid letter by my letter dated 20 June 2009, addressed to the SP NIA camping in Haflong, wherein I conveyed the requisite information as per available records. Exhibit 271 is the said letter, 271 is one is by signature. By the said letter, I have conveyed the list of cases with brief in which Joel Garlosa.
Take out exhibit 271. Yes, carry on, carry on. You continue.
271, I'm sorry. In which Joel Garlosa, Mihir Barman, Partha Varisa, and Surinda Varisa were charge sheeted, along with photocopy of charge sheet. Also, the letter contains a list of cases pending under investigation at the point of time in which Joel Garlosa was involved, as well as a case brief of the incident dated 14/6/2009, which occurred at NC Hills Autonomous Council Office. Exhibit 271, 271-3 are the list of cases where charge sheet against Joel Garlosa was filed. 1 and 2. By letter number so and so dated 6/11/2009, addressed to the Inspector General of Police, I've conveyed required information as sought for by his office, by memo number so and so dated 28/10/2009.
Yes.
The information relates to the certified copies of FIR of cases registered in NC Hills district in connection with incidents of snatching weapons from security forces after being attacked. I've also furnished a copy of the list of weapons deposited by the surrendered DHD cadres, which means that the surrendered DHD
Which
cadres.
means your interpretation we'll talk about later.
Lordship.
You continue first.
Lordship.
You first read the statement and then try and convince what he has said, what his evidence is worth for. Then we will highlight the incompetency of your counterpart in the trial court. We'll tell you what they have done in such a grave case. It's a fit case for sending also all those people home.
Lordship, I will not.
It was callous, rank negligence. We'll tell you why. Carry on.
Lordship, I will
No,
not.
you can only make a comment on the evidence which is there. but-
Whatever is there on record, I.
But
try to-
this was a case of such grave allegations and the reckless manner in which it was investigated, first of all. And then the trial was conducted. It's pathetic. You carry on. We'll tell you why we are saying so.
Lordship. I have also furnished a copy of the list of weapons deposited by surrendered DHD cadres. Exhibit 272 is the letter and 272-1 is my signature. 72-2, 273 and 272-4 are the list of cases where arms and ammunition were seized by extremists. Exhibit 272-5 is my signature, 272 so. The DHD cadres came over from the jungles before the civil administration in batches, and two major batches surrendered on 13th and 14th September 2009, and they were housed in safe locations. Subsequently, a formal surrender ceremony was organized in district headquarters, Haflong on so-and-so, and was attended by the Chief Minister of Assam, senior officials of the state and district administration. I was present in the ceremony, supervising the arrangement of superintendent of police. In the aforementioned ceremony, Niranjan Hoja was the senior most DHG cadre, along with other cadres who led the surrender ceremony. Today, I have seen Joel Garlosa in court. Now, the cross partnership.
Yes.
At that point of time, I was superintendent of police NC Hills. The letter dated 16/6/2009 by which DIG NIA so-and-so sought information with respect to above case is not available today in court. I cannot remember now whether the aforesaid letter as received by me was under section 91 CRPC expressly or not. Status of investigation at that point of time as stated in my reply. The memo number so-and-so in reference to which I gave my reply to Inspector General of Police, CID and Nodal Officer NIA is not available in court today. I do not remember now exactly the information sought by Inspector General of Police. CID was under section 91 CRPC expressly or not. However, in the interest of general supervision, we were required to reply to queries from senior formations in the state police like CID, special branch, etc. I'm aware that as per provisions of section 91 CRPC, any court or any officer in charge of police station can issue summons for production of documents of a thing before such court or such officer for such information, inquiry or trial. On being shown exhibit 272-6 to 272-8 consists of 3 pages wherein my signature is only in the 3rd page. So Lordship, Lordship can evade. Next Lordship, Niranjan Hojai. My testimony in this case is by far based on the available documents. I do not know the status of the trial in these cases as on today. I do not know whether some cases have been dismissed by the concerned courts. Though I have myself not prepared the list of weapons surrendered, the list has been prepared by my subordinate staff. From the available record of weapons surrendered physically, the source of record from where the information in the list was gathered is not exhibited today. It is not a fact that DSD cadres have surrendered without arms. It is not a fact that I was not present in the surrender ceremony. It is not a fact that on the concerned day, that is 2nd October 2009, accused Niranjan Hojai was not present. Now from this, what I want to place before the
Read your documents, sir, first. He is simply giving, what he is doing is, he is filing some documents on record. He is a postman, nothing beyond that. He has not seen anything personally. Again and again, fall back to 60 and now come to 270. your document. What has he conveyed? Where is your list? Read. 1213.
1213 is the list of cases, Lordship.
Yes, all right. Show from this list, in which case was Joel Carlosa charge sheeted?
He has not been specifically mentioned in this case.
Then the evidence of this witness is on the face of it fit to be discarded because he sends the list by captioning it, list of cases in which Joel Carlosa was charged.
Lordship.
This amounts to an attempt to fabricate evidence. Read page, your document, forwarding letter.
Lordship.
With reference to the form furnishing following information desired by you. List of cases in brief, with brief in which the accused so and so was charge sheeted.
Charge sheet.
All right, tell us which case. Ashindra was charge sheeted. Which case? In
That is.
the entire number of cases, there is only one case where there is a reference of DSD. In none of the other cases has it been mentioned that DSD has anything to do with it.
Lordship, right?
There's only Umrang Suk 3/8.
Lordship.
DSDJ extremist. Which was the extremist? Why didn't you file the charge sheet on record? Then it would have been known. They are entitled to say that you have concealed documents. So this postman of yours, what he has posted and what forwarding letter he has prepared, he is not aware of it.
Lordship will consider the list of weapons.
Yes, list of weapons. Let us see that also, yes.
Lordship will find that at 1216.
1216, read please. Exhibit.
It is,
1216 then.
It is 272.6.
272.6.
272.6.
Read. We read it the other day.
Lordship.
And the simple question is, read the heading of the list. Who has surrendered the weapons?
DSDJ cadres, Lordship.
Who? DSDJ cadres is a very vague term. He is not the person before whom the surrender took place, right?
Lordship, he is the person before whom.
So, all right, let us see who is the DSD cadre. Who was there on that day? Is he a signatory? No, he is not a signatory to this document. So how is he supposed to prove it? (272)
Lordship will find the signature at page 1218 below.
(272)(9). Yes,
Eight.
yes. Who was the person, particular person, DSD cadre? Is it his whims and caprices we have to accept? Which DSD cadre, sir? How many persons were there? Who brought it? What was the action taken?
Lordship, that is.
It's not there. You are dealing with a criminal case beyond all manner of doubt, beyond every shadow of doubt.
I do agree.
Vague statements will not work.
I
sir.
do agree, Lordship. And, I put it on.
Then he says Niranjan Ojai was leading the surrender ceremony. Show us the document which records his presence.
That of course, Lordship, surrender, that has to be there.
That is why the comment,
Lordship,
callous conduct of trial. Yes.
Next, Lordship, I inform your Lordship that something, Lordship, not in this case, but Niranjan ho jaye and Joel Garlos, Lordship, they had preferred the bail application before this honorable court. Where they sign it stating themselves to be the chairman of DHD and the commander-in-chief of the DHD, Lordship. This is a matter which Lordship can take judicial notice because
Law is otherwise. Statements made in bail applications cannot be read against.
it's
the
not
accused.
the statement, Lordship.
It's a statement. It's a statement made that he is the chairman. It can't be read against the accused. There are not more than one Supreme Court judgments. Let us see the application. Show us,
Lordship,
show us the application.
I'll just flag mark it.
Yes, let us see. For your satisfaction.
Yes, yes, sir. Next page.
Now you, Ms. Chaudhary,
Lordship.
you said that the surrender of the weapons was before this witness. See his cross-examination, page 467. Though I have not myself not prepared the list of weapons surrendered, the list has been prepared by my subordinate staff from the available record of weapons surrendered physically. This even surrender was not before him. His list is a subsequent document. The surrender was actually on a different occasion. This is a compilation. So where are the original surrender lists?
Lordship.
You may write anything. You may even have written ISIS. Who stopped you? This is a list prepared after the registration of this case. After the registration of this case. So obviously the focus was on DSDJ. So you could have written anything. All right, give us the application. Let's see.
Lordship, you'll see the flag.
Yeah, we'll just have a look. Season's greeting. All right. It's not a document on record. It's 2012.
Yes, it's got.
Rehabilitation process. Then 2012 again.
Lordship, you'll see how they have signed it. Lordship.
All right. These are 2012, not bail applications. They are not bail applications.
This
They are
is-
proposals to take their cadre.
This is a part of the bail application.
GB, sir. Maybe, and Joel Carlos has not signed it.
Yes, he has signed it.
Niranjan and Devolal.
I will show Lordship. He has signed.
The three flags you have given us.
I-
Joel Garlosa, SD.
No, no.
SD.
It's in the next page, Lordship. You'll see.
Let's see, let's see.
I'll show you. Lordship.
Yes. Joel Garlosa. You could have brought them on record. There was nothing which prevented you. Anyhow. Take it back. Okay. Yes. So two of your witnesses have been done and dusted. Next what? Which witness do you want us to read?
46, Lordship.
46. Yes, 46. Page number.
Page number, Lordship, 378.
Say something. Naring Dolaguppu. Batai.
Hmm? 46. Lordship, of Lords, 378. I joined DHD in 1995. This is a militant organization led by Joel Garlosa, who was the chairman of the group. I remained with the organization from 1995 to.
He is destroying your case. It doesn't say that it is a terrorist organization. A very specific law we are dealing with.
Yes, yes. Lordship.
So militant organization,
Lordship.
you rely upon this witness and you give up your case. Because he doesn't say that it is a terrorist. In his chief even, you don't even make an effort of indicating that actually they were involved in terrorist activities.
Lordship.
And then read his cross-examination.
Yes, Lordship.
Bottom 7 lines. Improvement.
It is not a fact that I did not state before the NIA that I went there to set up base for the organization, but I could not set up the base because of financial problem, and so I returned. It is not a fact that I did not state before NIA that in the organization chairman was Joel Garlosa, vice chairman was Dilip Nunisa, commander-in-chief was Pranab Nunisa. It is not a fact that I did not state before NIA that our militant were always on mobile and cadres used to move. So the arms and ammunition were received at different places. It is not a fact that I did not state before NIA that on 1st January 2003 ceasefire.
This chairman and the vice chairman and CNC, he talks about DHD prior to 2003. After 2006, it is his perception that Joel Garlosa has formed a separate cadre. So what happened after 2006? We are dealing with the subsequent period only.
Lordship.
What happened after that? The witness is silent about that.
Yes, Lordship.
And as we have pointed out, he nowhere says that it is a terrorist organization. How is that inference to be drawn from his statement?
Yes. So basically, Lordship,
In the entire statement,
Lordship,
tell us what is the activity of this organization?
it is not there, Lordship.
All right, there is an organization which procures arms. That's all what his statement is. Is his 161 statement available? 161 statement. Because again, the same situation, not proved. Is it available?
It has not been exhibited, but it will be there.
It has been asked to the witness,
will be there.
so we can read it. Point it out. Yes.
Lordship, volume 7, page 1799.
Volume 7. So you refer to Amitabh Sinha,
That is,
PW 24,
that-
then it was
that is
Tanka, PW
72.
72. Tanka. And this.
This is
person was
46,
PW
46.
46. For Dolabu. What's his name?
Nine.
Naring Dola. Next, you are relying on PW
Lordship wanted to see
161,
page 179,
179,
9,
exhibit.
paper book. Volume 7.
1799. Just hold. No, I'm, yes, yes.
May I read it, Lordship?
Yes.
I was an original member of DHD in 1995, along with Dilip Numisa and others. Our president at that time was Joel Galosa, alias Mihir Burman. He used to organize training
Yes.
for the cadres and procurement of arms. All demands for money from contractors, sawmill owners, department, etc., were made by him. The arms were mostly procured from Bangladesh. I went twice to Bangladesh under his orders to procure arms for DHD. There is a place called Cox Bazar in Chittagong Hill Tracts district in Bangladesh, from where the arms are procured. A NSCN IM's commander by the name of
No,
George,
he doesn't say that Joel Garlosa was responsible for creating DSDJ in this 161. All right. Almost all 161 statements are available in this one.
no, sure.
इसके पहले वाला भी निकाल देना वॉल्यूम 6 पे निकालो. Yes. Oh, carry on.
Lordship will come to the second paragraph of this. I'm just,
Forget it, this is 161,
I'm just continuing. Lordship.
not to be read, otherwise also not to be read. Just can't be referred even.
Lordship.
Yes. It's just for our satisfaction that we were asking you.
I just wanted to point out one statement here.
161, it's not at all to be referred, sir.
Lordship.
You had the opportunity to rather declare him hostile. There were many things stated by him in 161. Who didn't venture into that. Yes, all right.
Just Lordship for this Amitabh Sinha Lordship, his 161 Lordship will find it 1154.
1154.
1154.
A paper book,
Paper book, volume 5.
volume 5 then away.
He is in the other case, Lordship.
Number 2.
Yes, Lordship.
छोड़ दीजिए उसको रहने दीजिए देखिए leave it. All right. Yes. Next, what you want to refer?
Lordship, from what I find in the judgment, Lordship, only these 3 witnesses, so far as section 16 and 20 are concerned of the UAP Act. 16 and 20 of the UAP Act.
Which is the other witness as per you who says that DSDJ is a terrorist gang? Who is the witness? Tell us first.
Direct-
That is the fundamental thing which we'll have to adjudicate upon.
I have not found any Lordship direct statement on that.
It's recorded. No?
Okay. It's okay. We understand.
Whatever
We
there is
understand.
on-
You have to argue on records, Mr.
Whatever is there on record, I cannot.
You have to argue on records. That's true.
And so far as lordship, the provision of section 25 1D of the Arms Act is concerned.
Yes.
Three accused, Niranjan Hojai, Joel Galosa, and Vallal Chaba.
Yes.
And
So Niranjan Hojai, about 25. What is the recovery effected from him?
no,
Read the finding whereby he has been convicted for 20.
lordship.
What has been attributed to him by the trial court? At least let us be sure on that.
Yes, yes.
Para
Para 460 of the judge.
460.
Finding it.
Which recovery is attributed? That so-called surrender of weapons.
My lord, surrender plus the Anurag, Amitabh Sinha's evidence, Anurag Tankha and Nairing.
If
That here is a part that weapons were bought from Bangladesh and all. I will argue on that point, madam. My short submission, let my friend.
I would take your lordship from finding the total. From paragraph 463 onwards,
That is a repetition of Amitabh Sinha.
yes, lordship.
Forget about that. It is to mention here that this list has not been disputed by defense side. Was there an admission denial exercise undertaken by the trial court that it was not disputed? Yes.
Lordship, may I read the subsequent two paragraphs? now? What is transpired from the evidence of these two witnesses are that there were arms with DHDJ and they surrendered in batches from March, April 2009. And two major batches surrendered before the civil administration in batches. And two major batches surrendered on 13-14 September. And they have deposited some of them with the administration while surrendering. They concealed some arms, some of them at Disa Kisan area, which were recovered on 8/7/2009. Though there is no direct evidence to link the arms with the DHDJ. Arms recovered from Disa Kisan area belongs to DHDJ. Yet the evidence of PW 24 is clear that DHDJ has not handed over all the arms. And on specific information and verification of the same, the said arms were recovered. Now it is to be seen from where DHDJ brought the arms and ammunition. In this regard, the evidence of PW 46, Naireng Dola Gappu, is material. He was a cadre of DHDJ. His evidence reveals that the arms and ammunition required for the operation of the organization were purchased locally. And
This is a misreading. He was not a member of DHDJ as per his own evidence. He said that he was DHD. Then there was a breakaway and DHDJ came into existence. So this is a misleading as a matter of fact.
Lordship, let us go to the next sentence, Lordship.
Yes, yes.
The arms and ammunition were received at different places since their militant camps were always on the mobile and the cadre used to move. So PW 20 is another cadre of DHDJ. His evidence also reveals that DHDJ started money collection and arms. Joel had approximately 60 cadres.
Please take the trouble of reading PW 20,
Yes, Lordship.
page 68. Where does he say all these things?
20.
Hmm.
I was a cadre of DHDJ of NCS for about 16 years. I joined, sorry. From the year 1996, Joel Galosa was the chairman. Dilip Nunisa was the vice chairman and Pranab Nunisa was the commander-in-chief. From 1/1/2003, DHD group entered into a ceasefire with the government. After ceasefire, Joel Galosa continued with the organization. He suddenly disappeared. We do not know where Joel Galosa went thereafter. We thereafter made Dilip Nunisa as our chairman to continue our organization. And till this stage, the said group worked and finalized the accord in October 2012. Joel Galosa group there should have been was also were the party to sign the accord along with us.
So
So
where does he say this fact the trial court has narrated in para 464? Does the witness say so?
No.
Rupam.
and then thereafter, Lordship, there is PW 129.
Yes, straight off the trial court says he has been declared hostile, but the IO said that the witness said so before me, so it is evidence. What is this?
Proved by the IO, Lordship. Through the IO, rather.
Could the IO have done that, sir? What to do about 162? Declare it unconstitutional. Okay, so this is 464. Now come to 465.
Lordship, Lordship is referring to.
Oh, you continue your arguments. 464 is completed. We are asking you,
Lordship.
are you proceeding on 465?
Lordship. No, I would take your Lordship to the evidence of.
So
PW.
regarding, now we were on 25. What evidence has the prosecution adduced to prove 25 against Niranjan Ojai?
Nothing. I do not find it.
Okay. Joel Garlosa. He was traveling with his two licensed weapons.
No, I was not traveling, man. Joel Galosa was.
Joel
That was
Galosa
Fojendra.
He was
Fojendra.
convicted.
He was acquitted.
My lord.
Joel Garlosa.
Joel Galosa was apprehended from Bangalore, Lordship.
So was he having any weapons?
No.
Did anyone see him with the weapons ever? Was any recovery proved against him?
Not him personally, Lordship.
So then 25. 25 conviction is not with the aid of 120p. It's in substantive,
Yes,
right? So for that, there has to be a recovery. So there was no recovery. It's a
only
fact.
the surrender of arms has been.
Surrender of arms. We asked you. Okay. Now next, there is one more who has been convicted for 25.
One other. I'm coming.
What do you say about it?
For that, Lordship, I would take your lordship to the evidence of PW 13 first. Very good, sir. Page 51, 52, volume 1,
PW 13.
1-3.
Yes. Yes. Will you like to read the finding of the trial court before that?
Yes,
Where is that finding, Mr. Burgoyne, where the trial court says that this recovery could not be linked to Vanlal Chana?
My lord,
There was
it is at para 466. It is to be mentioned that they accept the version of the accused that the arms were meant for.
No. We are talking about this recovery from Aizol.
My lord.
There was one finding which was pointed out by Mr. Kamar as well as Mr. Mishra.
My lord, here only, there is no direct evidence to link the recovered arms with DSDJ.
No. Vanlal Channa's recovery. Aizol.
Aizol, my lord.
Yes.
It is.
There was a pertinent finding that recovery could not be linked to him.
My lord.
Paragraph 465 and 466.
No, before that.
A specific role with respect to Vanlal Chana, my lord.
Yes, read that part. There was a finding that this recovery was made beforehand and the arrest was subsequent. Where is that discussion of Vanlal Channa?
Vanlal Chana's discussion comes at para 199.
Yes, read that.
Lordship will perhaps refer to paragraph 203.
Paragraph 208.
Although the disclosure statement exhibit 43 is inadmissible here in this case, being not recorded prior to recovery of the arms and ammunition, yet the facts remain that the arms and ammunitions were recovered and seized on being led and shown by the accused from the house at Serong Byang. The arms and ammunition so seized were duly seized and exhibited in the court as material exhibit, so and so, with
Yes.
magazines.
All right. Yes, so about Vanlal Channa, you are referring to PW 13. Read, please. Now you will have to deal with two Vanlals. Which Vanlal?
Yes.
Read.
At page 51.
Yeah.
Since 1995, I have been working as sub-inspector of police, government of Mizoram. In the year 2009, I was working at Aizol police station as sub-inspector of police. When I was in Aizol police station, I took up the investigation of Aizol police station case number 238 of 09, dated 18709 on the.
So why didn't you take the trouble of producing this FIR on record, sir? Neither the FIR nor the charge sheet. Why? There were some skeletons in the cupboard. We can tell you, in all probability, these were the very weapons which were recorded on 18th July. This memo is a fabrication. And that is why you did not produce this FIR. You say that the FIR was registered on 18th July against Vanlal Ilyas Ventia, Vanlal of Aizol. The other Vanlal you have arrested, who happens to be the accused here, he is an outsider, but his passport says he is a resident of Aizol. So why is he not the first Vanlal? and the second Manlal is someone else.
Yes, Lord.
Yes, all right. All right, you get your.
Lordship, because these are the, I cannot go beyond this.
Yes, all right. Carry on.
When I was in Aizawl police station, I took up the investigation of Aizawl police station case, number so and so, against accused Vanlal Chama of Soreng Bang, Aizawl. During further investigation, another person with Vanlal Chana Ventia, who is temporarily living in Sarwar, Aizawl, is also suspected to have involved in the above case.
Yes.
He was then arrested in connection with the above case and forwarded to Aizawl court for a remand of 4 days. The prayer of police remand is allowed by the court. During the remand period, he was interrogated but could not find his actual involvement in connection with the above Aizawl police case number so and so. He was then forwarded to the court praying for discharge from the liability of the case.
So,
However,
Mr. Chaudhary,
yes.
there's a very important fact that this recovery, you got Vanlal Channa discharged. How can you read the same recovery against him? You have not included FIR number 238/09 in the NIA number 1.
No.
So that recovery continues to remain in that case. You got Vanlal discharged, saying that no connection.
Lordship.
Read on.
Lordship. Lordship.
Who was the officer of Aizawl who effected that recovery on 30th July?
For that, Lordship, if I may take your Lordship to the next witness.
HS Kamrial. No.
PPW 14.
14.
NIA took him on 30th, 31st. This, I'm taking your Lordship to page 53, the same paperwork. PW 14. In 2009, I was posted at CID's special branch, Aizawl. In June 2009, a team of NIA came to Aizawl for investigation of NIA case number 1 of 2009.
No, you just, yes, read next line. They were looking for one.
Looking for one armed smuggler.
Armed smuggler.
Identity we later came to know as Venisam,
Venichem, Ventia, Vanlal Channa, son of so and so.
Saron Wag. Aizawl, we arrested him at village Lungwat on 26/7 around 3:30 AM. He was later taken to Aizawl and interrogated. Later on 37, he made a disclosure about weapons, which he kept in a house.
No, just, Mr. Chaudhary, get back to your PW 13. He was wanted in NIA case or wanted in Aizawl case? Read PW 13. This witness say that Vantia was arrested and interrogated in connection with NIA case, right?
Lordship.
Now, what does your PW 13 say? So if your PW 14 is to be believed, NIA kept him in illegal custody for 4 days, 5 days, right? Because you did not prove the arrest memo of that case. PW 14 says NIA came suspecting him took him and interrogated him.
No, Lordship, this is the CID who has taken it.
Read please again,
Yes.
PW 14 carefully.
Yes, Lordship.
Hmm.
We arrested him in that village, so and so, on 26/7.
NIA came, they were looking for so and so.
Yes.
We arrested him. So your theory is contradicted because what you are saying is contrary to what PW 13 says. He was taken to Aizawl and interrogated. Later on, he made a disclosure. And then in that Caesar memo, you very easily get Kamrial to sign.
Lordship.
Very conveniently. All right, carry on.
Later on 30/7/2009, he made a disclosure about weapons which he kept in a house located at Saron Bank, Aizawl. The name of the house owner was Lal Rover. The search team conducted the search and recovered 8 numbers of MI16 rifles.
Why was Lal Rowan not impleaded as an accused, arraigned as an accused in NIA case? He was responsible for hiding the weapons. There was a lady who you arraigned as an accused in connection with that recovery. Why she was left out?
Lordship.
What was the motive for your IO to do that? Was there any sinister motive underlying? We don't know.
Lordship.
Gratification in some other form?
Material instructions.
All right, carry on.
Earlier, we have also recovered one passport which was in the name of Vallan Chana. The accused was later taken away by the NIA team. Exhibit 43 is the disclosure memo so and so, which I have prepared on the spot on the disclosure made by Vallan Chana. So and so is my signature. Exhibit 43(3) is the signature of the house owner, La Roba. 43(4) is the signature of another witness, Zuhair. As the accused was detained in Aizawl police station, case number.
So now, a self-contradictory version. There are two Manlals. Who was detained in Aizawl, who was detained in NIA?
Lordship, if your Lordship will kindly take page 51 for a moment. Where the names appear. When I was in Aizawl police station, I took up the investigation of Aizawl police station case number so and so. Under so and so house.
Yes.
Against accused Vanlal Chama.
Son of Saran Bank Aizawl. Right? So this is one lal. This is one lal.
This is
one lal one.
This
one lal A. Okay. Then next line.
in further investigation, another person.
Viz. One lal is alias Ventia, who is temporarily living at Saran Bank. So one lal A is the permanent resident. One lal B is the temporary resident.
Temporary resident.
Who was taken by NIA?
Lordship.
He was then arrested in connection with the above case. So he was then means one lal B, right?
Lordship. There's some ambiguity out here.
So one lal B was arrested in Aizawl case. One lal A was taken away by NIA. That is your case. Okay?
No.
No. So you just satisfy the court. Who was the one lal?
The one who was taken away, Lordship, is mentioned in the evidence of PW 14.
Read, sir.
One is, the other one is
Yes.
Vanlal Chama of Saranway.
Son of Nung Kip Thang of Saranbang. Now you let us have the passport of the accused who has faced trial. What is his name? Is his father's name this same one? Now, all right, read from the title of the case. Who is the accused who has been convicted?
Page number 170.
Vanlal Thana Venki.
Where is the parentage given in the judgment? The father's name is not mentioned.
Father's name is here. It's not there.
Case of mistaken identity.
Yeah. Exhibit 44. Yeah.
Okay, we'll see. Carry on, carry on.
In the charge sheet, it is there, Lordship.
What is the name? Let us see.
Uh,
What is the father's name?
That that goes by N. N,
In charge sheet, it goes by N.
N, N.
And who is the person tried?
Lordship.
What is the father's name of the person who has been tried? Read the charge for that purpose. Where is the arrest memo? The arrest memo is that prepared on after his custody was taken. Let's see that. Exhibit. That is just after the recovery. 43, paperwork, exhibit, volume 1.
Page 79, Lordship, you can find. And that's the closure. memo. Wait, that's it.
Calling the person who has been given in custody is HAULIP. What is it?
Honor, HAULIUPTHANGA.
Calling.
My junior may read it properly. He's from Mizoram. Definitely. And your lordship will see one more thing interesting. Kindly come to the passport. Exhibit. They have exhibited exhibit 44. They have not exhibit. They have exhibited the first page of the passport. The last page we have our parents' name. That has not been brought on record. But the visas.
These are there.
Nothing. Nothing. The name of the father. That has not been brought. Something is.
Here is first exhibit. Let's see the exhibits. 43.
Passport officer का PW निकालो.
Hokip Thang of Hokip Thanga. Read at page 77. Name of the person forwarded. It's not here. They are not in this page. The last page they are not exhibited. That's what he was saying. Read page 78 of the exhibit. Yes. Then come to page 79, disclosure memo. The name of father is entirely different. Ngunkipthang. Whereas he's this guy whose disclosure statement is there, he signs Vinay Chem. And if you see the court's order, whose custody has been given, read page 77. Vallal Channa is Ventia, son of Haukipthanga. Seems that Vallal Channa A his custody has been given and this disclosure is by Vallal Channa B. How do you reconcile, gentlemen? Do we have the signature of this accused anywhere? Mr. Burgoyne?
Pardon, my lord.
Vallal Channa's signature, specimen signature, anywhere?
313 statement. It will be there.
Please, let us have a look at it.
Paper book, volume 5, my lord.
Volume 5. There. Here. This is it. 1174.
1174.
This is not that. Okay. Oh.
I have seen in my lord, he has got a full signature, full name.
Just let us see. We will get
1174.
We'll get. See, the strokes are very prominent actually. So it can be made out very easily.
Exhibit the disclosure, your lordship.
Yes.
Signature is Venison.
Venichem, yes. This is a different man, Mr. Chaudhary. Look at this. Can't be the same. Now, still, you see the stroke C. This C makes it very clear. You take out 79, you take out page 1175. It's a different man who is. Because the father's name is different. What name he has given out in 313?
313.
He writes NGU.
NGU.
So that again.
The question is that, my lord, if this person both are the same person, how can their father's name will be different?
In this HAU, Hokipthanga, the one whose custody has been given. Discharged. So who was arrested by the NIA? There is the arrest memo by the NIA.
That has not been exhibited, madam.
NIA arrest memo is also not.
Not that. That was the reason why I wanted to argue on 25(1)(d) on this aspect that your lordship has taken.
It's the disclosure statement and the.
It's all right, but as a matter of fact, this seems to be a wrong record. His signature and this signature are not. As per the documentation, why don't give the disclosure was not found involved ultimately. That is why they got him discharged. And there the father's name is different. So this NJU seems to be polar. This guy must have been the same, was discharged. Why NIA did not exhibit the arrest? And neither arrest memo, 239 is proved, not neither nor arrest. Yes. When was he arrested? Mr. Chaudhary,
Yes, Lordship.
in all probability, what has happened is the disclosure is by the man who was arrested in 239. The father's name, there is some mistake in recording the memo. That is intentional. We cannot comment as on date. Looking to the fact that how could Kamrial reach there? And if he was interrogating the man in NIA, why is the disclosure shown in 239? Okay. So there is a difference in father's name. There is a difference in signature apparently. One who has signed the disclosure memo is not the person who has been put to trial here. That we can record very easily.
Moreover, my lord, the identification that he is the man who on the date he made the disclosure, that has to have been proved by PW 13 or 14.
Yes.
No identification in the court.
Yes.
No identification in the court.
Yes, all right. Sure, all right, carry on, carry on. Whatever. Apart from the fact that this recovery could not have been read against this, whosoever the Vanlal was, because seizure was made beforehand. Let's one see the seizure memo. Exhibit P. 250. No, the seizure of weapons from that Aizol. 250 page number. What is the page?
11.
Yes, 51, 53. We have it. We have it, yes. As we pointed out, no FIR number. And then this seizure is in pursuance of a warrant. It's a total mess. And if the seizure was from the accused, or at the best of the accused, why he didn't sign it? Come to 1154. So this part where the trial court holds that this is a seizure made at the instance of the accused seems to be a perverse finding on the face of it. Come to 1154. Not a whisper that in furtherance of information or at the instance. You have it?
This is the warrant.
You got it, Mr. Chaudhary?
Yes, yes.
Read. What is the recovery? How is the recovery done? In pursuance of the warrant of search of suspected place issued by magistrate on 30th July. That warrant has not been proved, obviously. The FIR number is not given. So your case that it was in connection with FIR number 238, that again is falsified. That it is in furtherance of information, this document doesn't say. So the recovery is absolutely of no worth. And then the bona fides of your IO's action. If Kamarial knew that he was doing it in connection with NIA, why the house owner and the tenant in whose possession the weapons were there, they were not arrested. Neither arrested nor examined as witnesses. So this goes. Next. What thereafter?
You know, 56. I'll be referring to two other PW's lordship, 56 and 63.
Yes, sure. 56 first. 56.
56.
Page. Kamrial. Okay.
At 418.
We'll continue at 2.
Lordship.
Has developed in the state of Assam, particularly district of Nagaon. My lord, I have communicated this thing to the honorable PS. What happened, my lord, yesterday in the evening, I came across some news article where it has been shown, reflected in the news, published in Pertinent Time and India Today. The midday meal scheme, my lord.
Children have fallen ill.
Fallen ill. Serious, my lord. I have got this thing. I believe that it should be taken care of, my lord.
You just provide it to the my PPS. We'll send it to the PIL committee,
my lord,
and they'll take it up.
My lord.
We'll instruct. Don't worry.
Because a lot of people, there is a CAG report also has come up, my lord. Rampant, lot of people are dying, and there's child, my lord. That is the thing.
So Buragoin, there are so many things in this state with which we are unsatisfied, but well, there are certain limitations. But we'll take this up.
Definitely, my lord. I'm grateful to that.
Okay. Yes.
What
is the receipt?
Take your lordship to PW 56.
56. Kamarial. Volume 2.
Volume 2, page 418.
Yes.
Page 418.
Page
418.
418.
418.
Right. Okay. Okay.
But I take your lordship to 420 for the Aizawl part. May I read it, lordship?
Yes. Come. Yes.
420, na? 420. Lordship said something.
Yeah.
Lordship, again, on 6/7/2009, I was directed by CIO to visit Aizawl and verify the visit of accused A. Warisa and develop the source information regarding the suspected accused who was supplying arms to DHDJ. Accordingly, I went to Aizawl, Mizoram. I collected the record of Hotel Tropicana where accused A. Warisa stayed in room number so-and-so from so-and-so in the said hotel. Is the said hotel guest register record showing the name of A. Warisa at serial number 6646. I also recorded the statement of hotel manager Sahabuddin to this effect. During my stay in Aizawl, it came to knowledge through sources that one Ventia alias Vanlal Chana a Myanmari national living in Mizoram is actively involved in smuggling arms and supplying to DHDJ. My source also informed me that he is having Indian passport issued by the Regional Passport Office, Guwahati. Thereafter, I came to Guwahati and visited RPO office and came to know that he had been issued a passport number so and so. I collected certified copy of the said passport file from RTO office, exhibit so and so other said documents. I handed over the investigation records to the CIO and also informed the inputs about Ventia over the investigation records. About Ventia to Mizoram Police. On 27/7/2009, an information was received by the CIO from Mizoram Police that they have arrested one Ventia Vanlal Chana on 26/7/2009, who during his interrogation revealed that he was instrumental in supplying arms to DHDJ. Accordingly, CIO directed me to visit Aizawl immediately. I reached Aizawl on 28/7/2009 and joined the interrogation with CIT, Mizoram team, in whose police custody Ventia Vanlal Chana was. During interrogation, Ventia Vanlal Chana has disclosed that he was dealing with DHDJ in supplying arms in the name of Joseph and known to DHDJ Chief Joel Garlosa and Niranjan Hojai regarding supply of arms. On 30/7/2009, accused Ventia Vanlal Chana voluntarily gave his disclosure to IO of Mizoram Police that a consignment of arms has already dispatched from Myanmar for DHDJ group and kept in the house at Saranweng area in Aizawl. On the basis of his disclosure, Mizoram Police obtained search warrant and he led to the recovery of arms and ammunition from the said place.
Now look how many statements he has given. See, number one, joined in the investigation being conducted by CID. Okay. Number two, that he was in custody of CID. Number three, Mizoram Police obtained the search warrant. So which is the correct position? Was it the CID? Was it the Mizoram Police? Was it a disclosure? Was it a search warrant? What was it? Okay, carry on.
I was also a part of the said team. From the search of the place led by accused Ventia Vanlal Chana. So and so this weekend. All the aforesaid articles were seized by season memo 250, exhibit 250. And I also appended my signature by exhibit 250/1 as a part of the team and token of its correctness. Two local witnesses, namely Lalrova and John Thanga, who remained present throughout the recovery procedure, also appended their signature in my presence on the spot as a token of correctness. So and so are there.
So Lalrova was the owner of the house.
Yes.
Okay. Why was he not examined? He could have said that it was Vanlal Chana who was responsible for the placing of the weapons in his house. Why was he not examined?
He was
All
examined.
Right.
Thereafter,
Yes.
CID, Mizoram team and myself returned to the CID office along with the seized articles and accused persons. During interrogation, accused Vanlal Chana revealed that his Indian passport is kept at his residence. D7, 37 Saranwang. Accordingly, a search under provision of 165 CRPC was conducted and his passport number so and so was seized. The passport exhibit 44 contains the details of his travels to Thailand and Malaysia. On 31/7/2009, interrogation of Vanlal Chana revealed that the recovered arms have no connection with the Mizoram Police case number 238/09, as they were meant for the DHDJ group and NIA case number 1 of 2009 is being investigated by NIA for the same. So Mizoram police decided to file a
So,
closure report.
But your officer knew it from before. Your officer knew it from advance. Even before Vanlal Channa told them or made them wise. That is why in the seizure report, it is not mentioned that it is being seized in connection with Mizoram police.
The-
That was on 30th July.
The PS case number is not.
So he
Uh,
became wise by the information given by the accused. Where is that information by the way? That Vanlal Channa enriched their knowledge saying, these are not part of the Mizoram police. These are meant for you. That is NIA. Where is that information?
That's- Uh,
Mm.
Accordingly, they filed a closure report on 31/7/2009 before the court. And I moved an application to take custody of accused Vanthia and Vanlal Channa and seize the articles. The Honorable Court allowed my petition and accorded 2 days transit remand to produce the accused person before the Special Judge NIA Guwahati. Accordingly, I effected the arrest of accused Vanlal Channa on 31/7/2009. After observing all legal formality,
Where is that memo of arrest of 31st, 31?
this memo is
Not on record, my lord.
I know, we know, don't worry.
where was it? And also requested the court to keep all the arms and ammunition by Mizoram police in their custody for security reason. And the court allowed my petition. Exhibit 251 is the taking and handing over note. 251-1 is my signature. 251-2 is the signature of SPCID Mizoram. All the arms and other articles so seized were deposited in the safe custody of 1st Battalion of Mizoram Police. Accordingly, on 1/8/2009, I took accused Vanthia Vanlal Channa to Guwahati and handed over to CIO along with all investigation documents. I have seen all the seized arms and articles in the court today, which are exhibited as material exhibit. Further on 9/11/2009, on the direction of CIO, I visited Aizawl and taken over all the seized articles from the Mizoram police. Exhibit 252 is the handing over record of seized arms and ammunition.
Just come to page 4. You will get signature. Yes.
Now, Lordship, the cross of Vanlal Channa,
That's very interesting.
423.
वहां से पता चलता है कि ये तो कुंभ में बिछड़ा हुआ कोई भाई मिला है आपको.
The address of the accused person. He is appeared from the passport application form received.
Is
from
Vanlal Channa son of Sulang Pik Hanga.
Ah.
And the man facing trial is, his father's name is not the same.
No.
So is this the passport of the man facing trial? Or you have filed a case for under the passport rules for getting a passport prepared in a false name? Carry on, please.
The birth certificates exhibit so and so. The address of the accused is shown as local area Aizawl, RD block so and so.
Come 4 lines below. In the passport related form, his name is mentioned and Vanlal Channa. No other names are written. Then the information what was received by me was not reduced on writing. Why? It related to another man. That's why.
Lordship.
Hmm.
The witness volunteers to say, I have mentioned in my supplementary case diary that in my supplementary case diary. All right. It is not a fact that I have falsely mentioned about the revelation by accused that the accused was instrumental in supplying arms to DHD for the benefit of prosecution. It is not a fact that I have falsely stated that the accused Vanlal Chana had supplied the arms to DHD group in the name of Joseph. It is not a fact that I have falsely deposed that on 37/2009 accused Vanlal Chana voluntarily gave his disclosure to IO of the Mizoram police that a consignment of arms has already been.
So he says that it is true. The meaning is, it is true that the disclosure was made to the Mizoram police. So now was it to the CID or the Mizoram police?
Lordship.
To whom was the disclosure made? Come forward, come 3 lines below that. There you will get what we were observing.
It is not a fact that the disclosure memo dated 37/2009 was
Not the disclosure of Vanlal Channa.
Not
It
the-
was signed by some other person.
by some
That is
other person.
absolutely gospel truth. It's not signed by this accused. That we can vouchsafe on the basis of the observations as they appear from the signatures. You have seen the 2 documents. So what is the consequence of putting up a wrong person for trial? Are there consequences? All right, carry on.
It is not a fact that whatever I have stated in my examination in chief regarding consignment of arms and ammunition supplied to the DHD by accused Vanlal Chana does not tally with the facts of the disclosure memo that the Caesar list does not contain the signature of Vanlal Chana. I do not remember whether the signature of the accused Vanlal Chana was taken on the sealed pack of the arms and ammunition. It is not a fact that during the search and seizure, accused Vanlal Chana was not present. It is not a fact that due to the alleged absence of the accused, his signatures were not taken.
Okay, what more do you want to read from his statement? Now, what do you want the court to deduce from the statement of this witness? What should be the conclusion? The one drawn by the trial court or anything else?
I'll keep it at that.
Skip. Pass.
There was-
Pass is not an option.
No, I'm not passing, Lordship. I would not.
We are asking you, the court is asking you to answer the query.
Lordship, apparently, there is a discrepancy.
Okay, that's a sensible answer. Okay. Without incriminating yourself.
Lordship, I will not incriminate myself.
Don't
because
do it.
whatever
Just
is
in the
there
lighter
is
vein. It's just in the lighter vein. Yes.
whatever. Then there is another PW that the court has referred to.
Tell us.
That is,
please. Who is that?
63.
PW
63.
63 page.
444.
Mhm.
444.
Lalrimwa. Right there. Deputy SP. Your Camarial doesn't even say to whom the weapon recovery was attributed, that name of the lady in Nampoi. He doesn't even speak that, though he claims to be present. All right.
This is Lordship only the.
My lord, may kindly see the Vanlal Chana's 313 statement.
What does he say?
Lordship, question number 69. Have you got anything to say in connection with occurrence of this case? He answers, I am innocent. I am not involved with any terrorist activities, including DSDJ. Neither did I supply any arms to them.
I'm a businessman at Aizawl and I've been falsely implicated in this case. The NIA has wrongly charge sheeted me in this case on the basis of list of some dealers available with the Aizawl police. And I am not that person as mentioned in the list. So he is answering, my lord, if we see the disclosure memo and the seizure and all those things, it was a planted.
What is the page of his statement?
My lord, your lordship will kindly come to volume 5, page 1196.
1196.
1196.
Okay, yes. Question number?
69.
Yes.
Lordship, page 444. In the year 2009, I was posted as Deputy SP, CID, SB at Aizawl. In the month of July 2009, information was received that one person suspected to be involved in arms smuggling was in Aizawl. In pursuing this information, one person, namely Vallal Chana Vantia, was apprehended about 40 kilometers from Aizawl. On his disclosure, the following arms were recovered. It's the list. After that, I was detailed to go to Kolkata, where one Mizo girl, namely Malsa Kimi, was apprehended by Kolkata police. This lady disclosed that she came by flight to Kolkata, where she was apprehended by police, and rupees 10 lakh was seized from her possession. Exhibit 258.3 is my signature in the said disclosure memo. She also disclosed that she went to Shalimar Hotel and Madhu Milan guest house with one George Lamthan for collection and transaction of money. Exhibit 257.3 is my signature in the said disclosure memo. George Lamthang also made a disclosure that he went with Malsa Kimi to Shalimar Hotel. And this is
What is the relevance of this statement, gentlemen? The statements referred to are of the co-accused persons. How they are relevant to Vanlal Chand. And what does he say? He doesn't say anything about Vanlal.
He only says regarding that recovery, Lordship.
Yeah, that's right.
And
it's again hearsay. He was not present there. And you have not examined the Caesar officer.
No.
Interestingly.
No, Lordship.
Yes.
So, Lordship,
what we feel is you didn't examine the Caesar officer because you were afraid that he will come and say that this is not the man. In all probability, yes.
I cannot.
There's a certainty we can tell you. Because that man was from Aizawl. He would have definitely said that, no, this is not the man whose signatures are there on the Caesar memo. Otherwise, what is the reason for you not to examine the police officer? Have you given any explanation? No. He was not even cited.
No, my lord. And even in that case, your lordship is fairly correct. Even in that case, they brought Mizoram police 2 officers, PW 13 and 14. Why they didn't ask him to identify in dock?
Yes.
He was there.
Yes,
He was
he's
in
right.
judicial custody.
Yes, yes.
And absolutely correct, my lord. He has been falsely implicated.
This is a possibility. We can't say that.
Inference we can draw.
Yes.
Possible inference is there.
Inference can be on either way. Either side.
It is recorded, sir.
Okay, carry on.
Lordship, so far as 25(1)(d) is concerned, Lordship, I find that the learned court below has relied upon these.
So 25(1)(d) argument is done. Next. throw light on terrorist act? Would you like to do that?
Lordship, I do not see.
No.
I would come to the recovery made. On,
1/4/2009.
yes, Lordship.
Hmm. Yes. Hmm. So before you make a comment on that, who is the witness who creates a link between Fozendra Ojai, Joel Carlosa, and what is that? The third person of DSD, Niranjan Ojai. Who is that witness who creates a link, even by inferences?
It's not a direct link, Lordship.
Inferences. We are giving you that liberty also.
Yes, sir.
Inferences to be drawn that there was a connection between Joel Carlosa and Niranjan Ojai and Fozendra Ojai.
Lordship, there is no direct link. It goes through the middleman, Lordship.
Okay. Argue. What do you want to read?
Lordship, I would like to take your Lordship to the evidence of PW 2, 10 and 26.
Yes. 2, 10, 26. Okay. Chandrakant, read.
Lordship, this has been read before also, but to make out my case, Lordship, on the recovery, I would like to go through it once again. Your Lordship will find that at page 15.
Yes.
I was posted at Vasistha PS from March 2009 as officer in charge. On 1/4/2009, I was working as officer in charge of Vasistha PS. On that day, additional SP headquarters Sudhakar Singh and additional SP Sri R. Rajkwa came to our police station and reported that some members of the DSD group are going to deliver money to the extremist group at Zorabad area. After getting the information, I deputed SI Maizuddin to go to Zorabad and inquire about the information. Maizuddin Ahmed came to the police station and deposited 1 crore, rupees 1 crore and 2 pistols and some articles after interception of 2 vehicles, which were carrying the above amount. And thereafter, he has lodged a formal FIR, which is registered as PS case number 170 of 2009. On 35, the IO, D. Saikia is also a PW, Lordship. I'll take your Lordship later.
Of course.
Of Vasistha PS case number 170 informed me that one accused named R.H. Khan involved in the case is residing at Tarun Nagar, by lane number 2, and sought permission to pick up the said person for interrogation. And accordingly, I went along with the staff to Tarun Nagar to the resident of R.H. Khan and found him in his residence and searched the house and seized rupees 4 lakh from wooden almirah of his house. The cash amount was seized and R.H. Khan was brought to the police station for interrogation.
What does he prove regarding the incident?
I would be for the seizure of 2 vehicles. The first paragraph is important. R.H. Khan, I will be referring to the latest data.
From the first para, tell us, the seizure was made. The information was that they would be supplying it to an extremist group in Jorabat.
Lordship.
Why was the information not followed? Why didn't they make effort to keep the vehicles as a decoy and lead them to the extremists?
Lordship, yes, that is a matter of the,
That is a natural consequence. You have an information, you carry it forward to the hilt, you pursue it to the hilt. Information was delivery of money to the extremist group.
Lordship.
Your focus was not merely on the recovery of money. Your focus would have been to reach out to the terrorist group and apprehend them.
Lordship, that.
Nothing
ought-
has been done.
That ought to have been, but Lordship, here is a case where they were on the recovery.
Okay. We'll talk about the recovery also.
Yes, Lordship.
Yes.
On the cross by Mohit. And so I'll take your lordship to the cross of Babul Kemprai first, because he was in one of the vehicles.
Why the GD entry was not produced despite opportunity?
Lordship.
Concealment of material evidence, what should be the consequence? Adverse inference. That is generally the principle in a criminal trial. Okay. Yes. Okay. Carry on. Babul Kemprai.
Babul Kemprai. I did not investigate the present case. When I deputed Maizuddin Ahmed for conducting the raid, a GD entry has been made in the police station. The original GD is not shown to me in the court today.
He did not depute Maizuddin Ahmed for conducting the raid. He deputed him to follow the information. That is his examination in chief. Inquire about the information. That is what the witness says. In that background, the GD entry assumes importance. All right. Yes, read. Okay.
The extracts of the GD numbers 1162 dated 1/4/2009 was recorded in my case diary, but certified copy of the said diary is not available with me. After the case has been registered, SI Bikul Saikia was entrusted with the case. So here he deputes Maizuddin to go to Jorabat. Jorabat, he comes back with 1 crore, 2 arms, and some documents.
Okay.
Now, Lordship. The next one. Is to PW10. Maizuddin. On 1/4/2009, I was at Basista PS as attached officer. On that day, additional SP Saudagar Singh, headquarter Guwahati, and additional SP B Rajkhwa, 4th FPBN, along with staff came to the police station around 6 AM. And they talked with the OC Chandrakanta Boro, that is the earlier witness, regarding DSDJ members involved in different unlawful activities. After their discussion, the OC directed me to go with the additional SP to Jorabat area for investigation regarding DSDJ extremists. During discussion, it revealed that DSDJ extremists were to move in 2 vehicles with cash and incriminating articles towards the direction with the purpose of purchase of arms and ammunition. The number of the vehicles were so this AS01 AH 1422, that is a Scorpio, and AS01 E 0609, that is a Tata Sumo. We proceeded to that Jorabat area after getting the information and for checking. We reached Jorabat at about 6:40 AM and started checking different vehicles. Thereafter, we were directed to go to 14 Mile GS Road around 12:30 PM by additional SP for vehicle checking, and we started checking the vehicles in that area. The aforesaid two vehicles, Scorpio and Sumo, came around 3:30 PM to that area. We stopped the vehicles for the purpose of checking. In the Scorpio, driver was Gunu Sonar. Passenger was Bhojendra Hojai. And in the Tata Sumo, driver was Dipankar Dhanka and passenger was Babul Kemprai. On inspection of Scorpio vehicle, I found two pistols in a briefcase and other papers and documents, and in the Tata Sumo, I found an airbag containing huge amount of Indian currency, covered by polythene and newspaper and by one blanket. Thereafter, I seized the pistol, currency notes and articles in the presence of witnesses and with the driver and passenger Babul Kemprai and Bhojendra Hojai. Bhojendra Hojai. Thereafter, keeping the articles and currency in locker for safe custody, I was directed by the SP, additional SP Sadagar Singh, to go to particular PS to file FIR. The cash which was seized was amounting to 1 crore. Exhibit 30 is the FIR dated 1/4/2009, reference to Basista PS GD number so and so, that was registered earlier. Exhibit 31 is my signature dated, sorry, Exhibit 31 photocopy is the format of FIR in 2 pages. 31(1) is the signature of Chandrakanta Boro under objection by defense as being photocopy. Is the signature Caesar list by which I have seized the Scorpio bearing registration number
Yes. Probably that is not one of these people. Yeah. Login of this. They must be. Yes.
I seized the Scorpio bearing registration number so and so along with RC book and DL.
You can forget those things. Letterheads, this, that, blah, blah, blah.
Lordship.
Yes. Okay. Then what happened?
Lordship will.
He seized, right?
Lordship.
Then what happened?
Lordship will come to
We'll
further examination.
do one question, further examination.
Further examination.
When? Where is it?
At page 40.
Okay.
Today, the original copy of the FIR, forwarding report, and the Caesar list are shown to me in the court. I say that the same are sent by me. Exhibit 36 is the original FIR format. 36(1) is the signature of Chandrakanta Boro, which I can identify. 36(2) is my signature. 37 is the FIR. So and so is my signature. And the register of Basista PS case number 170/2009 under 120B, so and so. The case was endorsed for investigation to needful psychiatry. Exhibit 38 is the original Caesar list. 38(1) is my signature. Accused Bhojendra Hojai and Babul Kemprai gave the signatures in exhibit 32 in my presence.
So
Now the lordship will come to the
Before coming to the cross,
lordship.
apart from the cash, there is one very important piece of evidence which this witness claims to have seized, that is those 3 letterheads.
Lordship.
What he did of those letterheads?
Lordship.
What he did? What was the fate? How were they kept?
That has not come out.
No one has argued this. We feel that here the lawyers are not used to arguing on link evidence. What happened to the letterheads? Where were they placed? Such letterheads can be printed 19 dozen in market. So what was seized at the spot? Whether it was sealed, whether it was deposited in the police station? Where did they go?
My lord, in 313, I have given answer that
There was no argument. That is what we are on.
My lord.
We can replay the recording if you want. There is a very important aspect to recovery cases involving recoveries in criminal cases. That is sanctity of the articles. Whether they have been seized, whether till the production in the court, there is evidence to show that the seals were never tempered. There is no argument. And for that, the depositing of the goods in the safe custody of the police station. Not only have you to prove the Malkhana register, but you have to examine the Malkhana in charge also. 0. Yes, all right. We need you to work on judgments on this aspect. There are few Supreme Court judgments on this. Link evidence of seized articles.
Take it up.
Yes. There are dozens of judgments on NDPS, but we don't want a judgment on NDPS. General recoveries. Still, this has to be any incriminating piece of article which the prosecution seeks to rely upon. It has to give link evidence to satisfy the court that the articles remained in the same condition till they reach the FSL, as the case may be, or produced in the court. Herein they have produced these letterheads claiming that Hossein Rozai was carrying it, and that is his link with the DST.
My lord.
So what is the sanctity of the recovery? Yes.
The cross on behalf of Babul Kemprai Lordship will come. Exhibit 30 refers to the Basista PS GD.
Why do you want to read the cross? You have to make out your case from your chief.
Lordship.
What has been made out? Let us know. Cross, they have already done enough.
Lordship. From the deposition of Lordship, this witness, what is clear is 2 vehicles. 2 vehicles.
Yes.
Fumo and a Scorpio, numbers are there. In the next evidence, it will come on in which vehicle, what was there.
Okay. So he is a police officer
Here,
of some experience.
Lordship.
He knows from which vehicle he has made the recovery.
Lordship.
Read the FIR he has lost.
Of
Read.
course, that is, I've seen that. But in his evidence, Lordship, he says from which vehicle, what articles were.
What should be believed, the first version in the FIR or what he says in the court?
That of course.
That of course. Okay, carry on. And where did he count all these things? Where did he count the notes? There's what we were commenting, why a single Caesar memo was made. There is a question to the witness at page 39. Though the articles were seized from 2 separate vehicles, but I prepared only one Caesar list.
Yes, Lordship.
Why? what was the material with this witness to connect the two vehicles? Because you say that there was a prior information. Where is that information? Not produced, right? Okay. And then read where he says that this counting business was done right at the spot, right? That has come in the cross-examination conducted by there is a pertinent admission by the witness. Okay, very interesting. Come to page 41. Cross by Debashish Bhattacharya.
Lordship.
What we are talking about sealing. You have that?
Yes, Lordship.
Last three lines. The seized articles do not bear the seal and signature of myself as the seizure officer. Besides this, there are no signatures of other seizure witnesses on the body of the seized articles.
Lordship.
This is at page 39. The second para, last 6 lines. So it took more than 1 hour for carrying out the said operation, including preparation of the seizure list at the place of occurrence. So before the counting was done, the seizure list could not have been prepared, right? So keep this in mind when you read Sudhakar.
Lordship. Lordship.
Now what you propose to read?
26, Lordship.
26. Is that page?
Uh,
Sudhakar Singh, yes, read.
135,
Read.
139. In the year 2009, I was posted as additional SP headquarters, Guwahati City. My duty and responsibilities were to look after office administration, manpower, so and so. On 1/4/2009, an information was given by the superior officer that one Mr. Pujendra Hojai of Haflong, now Dimahasa district, would be carrying a huge amount of money, near about 1 crore, to be delivered to some armed smuggler, and I was asked to put nakabandi and apprehend him.
So see how far advanced Moizuddin Ahmad is. Sudhakar Singh never had any other information. Moizuddin says information even contained the numbers of the vehicles. Do you recollect at the beginning of Moizuddin Ahmad? Okay, read on.
So with a team of Vasistha PS and other officers, we laid a naka at Zurabad early in the morning of 1/4/2009. After conducting the naka for some time, we changed our location to nearby 14 mile on GS Road and started monitoring the vehicle which were coming by. And in the afternoon, we spotted Mr. Pujendra Hojai in a Scorpio, which was followed by a Tata Sumo. These two vehicles were moving together and they were stopped by us near 14 mile. On checking the vehicles and the persons, 2 pistols were found with Mr. Pujendra Hojai, of which he had license for one and the other was without license. In Tata Sumo, a bag was recovered which contained huge amount of money. On spot interrogation, it was stated by Pujendra Hojai that on direction of one Mr. Niranjan Hojai of Dima Hasao, he was carrying the money to be delivered to one Mr. Liana, who is an arms dealer.
So your Chandrakant Bodo says the money is to be delivered to extremist group. Sudhakar Singh says to arms dealer.
Lordship.
Okay. Arms smugglers.
The persons apprehended with the money and weapons.
The extremists were the persons to whom the arms were to be supplied. He talks that this money is to be given to the
Lordship, this
arms
perhaps
smugglers.
normal language, Lordship.
Normal language, yes. The specific language would be in the information, which we don't want to disclose. It is privileged document.
I would rather put it this way, Lordship.
Yes.
In normal the conversation, we would equate an extremist with a terrorist and a dacoit. Goes every.
Okay.
The persons apprehended with the money and weapons were brought back to Guwahati, both APB and guest house, where the money was counted.
So the counting was not done at Jorabat, 14
It
miles.
was done in the guest house and found to be amounting to rupees 1 crore. The recovered articles were seized by IO SI Moizuddin Ahmed of Basista PS. Again on 1/6/2009, I along with 2 inspectors and a constable flew to Bangalore. This lordship will be called Joel Garlosa lordship. But let me complete it. Again on 1/6/2009, I along with 2 inspectors.
All right, he arrested Joel Garlosa, Partha Varisa, yes.
Lordship.
Samir Ahmed, yes. Then
Now, crossed by Babul Camp, right?
why do you want to read the cross? What is the significant point? You read out from the cross and what you want to gain from the evidence of this witness. Your case would be simple. Caesar has been proved.
Caesar.
All right.
I hear it.
Pertinent answer. The goods were brought to the guest house
Lordship.
where the Caesar list was prepared.
Lordship.
And then he further says at the time of preparation of Caesar list, I was not present. So he neither follows the lead of the extremist group, nor does he stay back when the Caesar is made. He's too busy elsewhere. Was it a Sunday? You wanted to play golf or what?
Hey, Gary, hey, driver sonar.
No,
Now, now come to the vehicles.
to the vehicles.
To the vehicles, how they were used.
Bunnu Sonar.
No, sonar. No, I got at the camera. PW, I got at 21.
Has the accused laid a claim to the money? Has the accused claimed the money? No. No. Why? Why shouldn't this be taken against the accused?
But I am not aware of it because I was in Bangalore at that point of time.
No, who represents Joel Garlosa? No, this Hosendra Ujai. The non-laying of claim to the money. Why shouldn't an adverse inference be drawn?
Mishra sir represents.
Yes. Mishra Sahab will be able to give answer to this query.
21, 72. If I may take your lordship to page 72 of
Yes, yes. Sure.
volume 1.
Yes. Chandra Sharma.
Chandra. I'm doing supply business. Lordship has got page 72. I'm doing supply business at Haflong. And I have a hardware shop at Silpukri. That's in Guwahati Lordship. My father was working in handloom and textiles at Haflong and he had retired from service. We have been residing at Haflong for about 10-12 years. I know Mohit Hojai. He is in politics. We have family touch with his family. He has got a daughter studying at Guwahati and I am close to him. I have been looking after the said
He is
daughter.
a hearsay witness, gentleman.
No,
He is a hearsay witness. He says Dipankar Deka called him, said the vehicle has been seized.
No. Dipankar Deka is his driver.
Yes.
Somebody else called him. I'm trying to make the chain, Lordship. On 1/4, Lama to
Sonam Lama called me.
on 1/4.
All right, you read on. Why didn't you interrogate Sonam Lama?
Lordship.
Why didn't your IO interrogate Sonam Lama? Give the answer. He was the person who procured the vehicle for transportation of cash. Most important link in this chain. Why he was not interrogated?
He was not Lordship.
So you read these statements and you land in bigger trouble.
I have no.
He says nothing.
No, I'm.
He only says that his vehicle was engaged and he got back an information that it has been seized.
No, there is something in between.
All right, there is something. Read that road. Read that particular line then. Don't read every line of the statement. You already been taken through that. Which particular line?
Accordingly, I gave the phone number of Lama to my driver, Dipankar Deka, and he took the Tata Sumo out for hire. Around 1-2 p.m., my driver telephoned to me and told me that he is taking the vehicle towards Shillong, and I instructed him to come back soon. On the next day, my driver's wife came and told me that the vehicle was seized and was lying at Basista PS, Lordship.
Mm.
Now, Lordship, look,
You read the statement. What is the argument on the basis of the statement?
that Lordship, his vehicle was
Taken on hire. All right.
was taken on
Yes.
hire. Dipankar took it. Dipankar.
What was the
guy-
number of the vehicle which was taken on hire?
Lordship, the vehicle number has been given.
Who will speak? The registered owner or someone else?
Here, Lordship, the police has identified the vehicle, Lordship, with Dipankar.
Oh. Have you proved the registration certificate?
No.
No. So how do you say that he is the owner?
Lordship.
Think before you leap. Don't go on randomly reading every statement. Yes.
Not.
Then he says Sonam Lama is a contractor resident of Haflong.
Yes.
You got the information. Why didn't you interrogate him? What was the reason for you to get the vehicle on hire? Why did you? Who was responsible for putting the money? Why didn't you interrogate Sonam Lama? Why didn't you follow that lead? These all add up now.
Lordship.
Nails in the fill in the blanks. Mm.
Lordship, may I take your Lordship to the deposition of PW 64,
Yes, sure. Volume
volume 2, page 446.
four.
Lordship, I'm sorry, I just mixed up. 135. With a law.
You're trying to read the statement of who?
Lordship, I was mixed up. If your lordship will take page 600, paper book 3, lordship.
Who is the witness?
Dipankar Deka.
Dipankar Deka. PW?
PW 113. In the year 2009, I was working as driver for one Sandra Sharma. Sandra Sharma was the earlier book I had read, lordship, who was residing at Silpukri. I was driving his Tata Sumo vehicle, which was used as taxi service. I was residing at Nunmati in a rented house. On 1/4/2009, Sandra Sharma rang me up around 8:30 a.m. and informed me that I am to carry some passenger for local trip, as well as I may have to take them to Haflong. He directed me to come with his vehicle to Zoo Road, Tiniali, and accordingly I came with the Tata Sumo vehicle to Zoo Road, Tiniali. When I was waiting there, one person rang me up and told me to take the vehicle to Ganeshguri near flyover and asked me to wait there. While I was waiting, one person came who has the look of tribal caste, boarded the vehicle with a handbag and directed me to drive towards Khanapara. On reaching Khanapara, he told me to proceed ahead to a Shillong road, where I filled the vehicle with fuel at NRL petrol depot. I drove the vehicle towards Shillong as directed by the person. Before reaching Borapani, an area called Sumar, we were intercepted by police vehicle. There was another Scorpio vehicle ahead of us, which was also intercepted. I was taken out of the vehicle. I also saw other Scorpio vehicle was also stopped accordingly. I was blindfolded by cloth and later I found that I was in Vasistha PS. There I was interrogated by police and after 2 days, I was released. On 3/4/2009.
So his statement gives rise to an inference that your police officers indulge in illegal detention. 2 days he was detained. You have called a witness who has stated on oath.
No, sure.
Is your public prosecutor who is making him to say so? Blindfolded, taken to the police station, interrogated, 2 days released. So 48 hours illegal detention.
313.
He has become a candidate for compensation. Carry on.
313.
Okay, what does he say? What do you want to draw from this witness?
From here, what I wanted to point out was, lordship, that Dipankar Deka had driven the vehicle where, lordship, there was another person, I'll be coming out right now.
Where was the another person?
Here, lordship. Here, well, there, one person rang me up and told me to take the vehicle to Ganeshguri flyover and asked me to wait there. While I was waiting, one person who has the look of a tribal caste boarded the vehicle with a handbag. I'll be coming to that.
Who is that person? As per you, just make an argument.
Babul Kemper.
Oh, is that so? Who says so, Mr. Chaudhary or
No,
the
it will- it
witness?
will co- No, no, it will come up from the witness.
All right, let us see. Good. Come from the witness, let us.
Before I take your lordship to the other witness, I would just refer your lordship to the 313 statement.
False, gentlemen, falsity in defense cannot help the prosecution. You first tell us from this witness whether he is able, whether you are able to make out a case that Babul Kemprai was the man he drove from this statement. Your prosecutor did not even have the guts to ask him that, look here, this is the man standing in the court. Is he the same man?
Lordship.
Why should we go to the 313? Make out from your own witness.
Because in 313 lordship, just for one moment. lordship, let me read.
What he says, you speak out orally.
He says, I was not aware of exhibit 388 but exhibit 388 is not correct statement. It is a fact that huge amount of Indian currency was found inside Tata Sumo vehicle number AS01E 0609.
All right.
But I did not carry any bags with money.
So he denies. He denies.
I'll come to that.
Yes.
I did not carry any bags with the money as the vehicle was going without any passenger. Therefore, on the request made by Phojendra Ahuja, High Contractor, I boarded the vehicle at Ganeshguri. He says Ganeshguri, he does not deny he has boarded at
But
Ganeshguri.
he doesn't say that vehicle, he was having any bag.
No, he does not.
So, all right.
I boarded, yeah. Sonar. Yep. 64. Volume 2. I take your lordship to the evidence of PW 64 Bunu Sona, page 446.
Four, 4, 6. Yes. What does he say? Volume 2. Yes, read.
In the year 2009, I was working as a driver and I was driving the vehicle of Phojendra Ahuja, which was a Scorpio. Actually, I was auto driver in Haflong and I was recruited by Phojendra Ahuja to drive his vehicle for 10 days. One day in the year 2009, the exact date and time not being remembered by me now, I drove the aforesaid vehicle from Guwahati to Guwahati from Haflong with Phojendra Ahuja in the vehicle. After reaching Guwahati, we stayed in Guwahati in his
It's all right.
house.
What he says is that yes, Phojendra Ahuja was traveling the vehicle and he was arrested.
Yes.
But gentlemen, now you come back to the statement 313 you were referring to.
Lordship.
Do you even give a suggestion to this witness? In the meantime, Phojendra Ahuja instructed another man to board a Innova with a bag. He was the person who was there.
Yes.
Is it your case? You are required to connect Phojendra Ahuja with that 1 crore.
Lordship.
Who says so? He was the person whom you could have given a suggestion that look here on the way Fosendra Rozai called one person, tribal caste. He was having a bag. He was asked to board the Tata Sumo. And Fosendra Rozai was continuously talking to that occupant on his mobile phone. You could have created this kind of evidence. So all creation, your IO was not wise enough. Therein, this is escorting. So this is a sequence. What has been shown is escorting. One vehicle carrying the articles, contraband or the money, and the other vehicle following as an escort. So they give information. Police dikh rahi hai to side mein ho jana, ye kar lena. In that, there in Rajasthan, it is very common in narcotics. Almost in 90% cases, two vehicles are apprehended. One is alleged to be the escorting one, and the other carries the narcotics. So the owner or the person who is actually the helm of the affairs, he acts as an escort. So therein, to establish the connection, the call details are brought in. That yes, the occupants were in touch with each other continuously. There have been investigations. The narcotics, they are picked up from Chittor district and they are taken to Jodhpur and other areas. So the IOs are smart enough. They get even the details from the toll booths that these two vehicles passed at such and such time. That is the quality of investigation we have come to expect. Yes, Bunnu Sunar, what do you want to say from him? That Fosendra Rozai was apprehended by the police. That's all. So it's a fact. There is an arrest memo.
There was another connecting.
But what is more significant is he doesn't say that any other Tata Sumo was apprehended along with my vehicle. You don't even suggest to the vehicle, to the witness. So what kind of inference is to be drawn? He is relied upon witness. All right. Why didn't you give a suggestion of the vehicle? Yes, contiguous to your vehicle, another vehicle was there. It was also seized. It was also brought to the police station. And therein, this Babulal Kamprai, who's standing here in the court, he was sitting. So you yourself have blown the fuse. There is no link.
Dipankar Deka says that he was asked to follow that vehicle, Lordship.
Oh, Fosendra Rozai was in this. Dipankar Deka doesn't give the number of the vehicle. He doesn't name Fosendra Rozai. Which vehicle he was asked to follow? There were thousands of vehicles flying on GS road on that day. Which particular vehicle? You had the opportunity. Dipankar Deka should have been made to identify. Fosendra Rozai could have been done. And vice versa. Bunnu Sunar.
That is.
So virtually you have created holes in your own story by your own witnesses. This is what is called a systematic demolition. What is that Japanese term? Harakiri. That's right. Ask your public prosecutor. Why didn't you put this question to the witness? That who was there in the other vehicle? Whether there was any other vehicle? Why didn't you come with that case? Yes. There were two vehicles as per you. You want to impute the knowledge of the goods contained in another vehicle to the occupant of this vehicle. Which other witness was there as per you to connect the events happening in the two vehicles? Come this way. This is just to find out what was the reason behind it.
Sorry, without going to all the documents, etc.
Yes.
But the whole thing started like this, Bharat, that ইয়াৰ নামটো শুনা না শুনিছে এই হেৰি টকা ফোন কৰিছিলে মানত Sonam Lama, he stayed all the time with accused number 3. That
Accused
is,
number
you know,
3
without
means?
going to your
Accused number 3?
Mohit Hojai.
Mohit Hojai, all right.
Mohit Hojai, he had a flat at GSO. And that is all it has come in.
Flat.
Now, on that particular evening, this man, he was with Mohit Hojai. He rang up PW21, that is
Chandra Sharma, to provide his vehicle.
that I want a vehicle.
Sonam Lama rang up.
I want a vehicle. Now, what it transpires, it is only what I am saying about the knowledge that the vehicle would be used for, let us say, it is an inference matter for carrying money. Actually. Now, in the morning, that is on fast. The owner of the vehicle, he said to his driver, go to a particular place and pick up sway. He goes to Jew Road area, where is the residence of Mohit Hojai. He get a phone, he get a call that, no, you go to Ganeshpuri. There he picked up, as it has come, my lord, accused number 2, that is Babul Kampra. They go and reaches a particular spot where they are interested. Now, with all these affairs, my lord,
These earlier parts you stated, they are not on the record. So forget about that. They may be in your knowledge. That is your personal knowledge, not a part of the record. You want to convince the court that Fozendra Hojai was having knowledge about the goods being plied in Tata Sumo.
That comes only from the 313 statement of Babul Kampra.
Could you anticipate that Babul, just hold on, sir. Could you anticipate that Babul Kampra will give that statement?
That is what has come, Mala. We cannot.
We are asking you, you were the prosecutor, you were required to prove this fact in your evidence. You couldn't foresee what will be coming in the 313. Apart from the fact that 313 of one accused can't be read against another. It's a settled law. There is no dispute. Even confession can't be read. Read H.S. Kurmi, Haricharan Kurmi, the 64 Supreme Court, and then Suresh Pudarmal Nayak. Now, what we are asking you that when you were examining these witnesses, why didn't it strike to you that it is the only person, Munnu Sonar and Dipankar Deka, from which we can get this evidence that there is a contact between Fozendra Hojai and the cash being carried? Why didn't you even give a suggestion?
Madam, that will be a joint liability, Madam, both to me. Whether, because they, Madam, what I would say, they had the knowledge.
What is the live link between two vehicles? Two vehicles are plying. We just ask you, say, an example sort of thing. There is something lying in the pocket of Mr. Chaudhary. How you can be attributed to the knowledge thereof?
If it is my knowledge, Madam.
Who will prove that? How it will be proved?
You keep it for timing. We'll see what happens. We'll go there.
Someone has to say that he saw you putting that thing in the pocket of Mr. Chaudhary. Or both of you talking about it.
I appreciate your lordship, Madam. I appreciate your lordship. Madam, this is what has come in 313. That's all. Nothing more than that.
Again, we are asking you, when you were examining the witnesses, that was before 313?
No.
Could you anticipate that this will be the answer in 313? Could you foresee?
Madam, generally the witness goes by way of 313 statement what he have they say. Oh no, Madam, 161 statement.
Then your IO was at fault. And then identification in the court. Who does that? Is the prosecutor's job? What were you doing? Why didn't you take that risk? Is he the man who was there in the other vehicle? could have taken that risk. Otherwise also your witnesses were turning hostile, right, left and center. Should have given it a shot.
I appreciate lordship.
All right, you can take your seat. So, Mr. Chaudhary, what is the live link between the two vehicles and the occupants thereof?
Lordship,
किससे कहानियों से केस साबित नहीं होता है. You need proof.
Lordship.
Right. Gossip is not the way to prove a criminal case. Okay, so tell us what is the live link? From what evidence do you want the court to infer that? The trial court has drawn an inference.
Lordship.
We'll deal with it when we decide the case, when we dictate the judgment. What is your argument? How do you attribute knowledge of that 1 crore to Fosendra Osai?
Lordship directly right.
Indirectly, inferences.
In inferences, Lordship, both vehicles were lying together.
How many vehicles are parked in the High Court campus? Can the owner of one vehicle be attributed knowledge of, can Mr. R.K. Dev Chaudhary be attributed with the knowledge of what is lying in the vehicle of Mr. Burgoyne, even if they are back to back,
Lordship.
parked back to back? Can it be?
The occupant of the Tata Sumo had told Dipankar Deka to follow the Scorpio.
Oh.
To follow the Scorpio.
Who says so? Who says?
Dipankar Deka.
That occupant of Scorpio, he was told to follow the Scorpio. Oh.
Lordship. Dipankar Deka को पता?
पढ़िए जी, वो भी पढ़िए. Read.
Dipankar Deka.
Dipankar Deka is PW 113.
600.
600. Yes. Read, please. Was he even having a knowledge about it? Does he even utter a single word about any other vehicle? Scorpio. Show us the word Scorpio in his evidence. Except for the fact there was a Scorpio which was intercepted.
Lordship.
But that's all. So he was asked to follow. Where do we get it from, sir? And he says, where was the incident? If you are relying on Dipankar Deka, your case otherwise also blows up in the face. He says it is Barapani. Did you declare him hostile on that?
No.
So then why shouldn't we believe this part of the evidence of the witness?
Lordship.
So inference, direct, indirect, from where do we get it? When we dictate the judgment, there has to be some argument attributed to you that they were in knowledge of each other. On what evidence? Or else we'll say, please go back to minute so and so of the recording, wherein Deputy SGI says no evidence.
Because
You
I
only have-
cannot improve on this.
You can't. That's a very fair submission. Yes. Next, what next? So this takes care of 1-4. Okay. Anything else to be added?
No.
Okay. Yes.
Apa betul ini? Apa tu kalau? No,
Yes. Yes, please.
that Sudhakar Lordship, I have already that it was supposed to be delivered to some Liana.
Arms dealer, extremist. Delivery was not certain.
The term was not certain. The term was not certain. Delivery maybe, but term used.
You know, there is a big hole in your case again. You are not getting the arms without the dollars. So why should it have been taken to Jorbat? It was to be sent to Kolkata, where it would be converted into dollars. Then it would fetch weapons. No one was giving you weapons for the Indian currency. So why were you taking it to give it to the extremists in Jorbat? Why they were taking it there? Is there the route to Kolkata goes through there?
In different ways, but because this 1 crore. They have not, APs has not stated what they have been carrying.
Which accused? Babul Kemprai.
It is within the knowledge that is 101.
All right, hold him liable for Income Tax Act, seize it, impose a penalty. What else? Undisclosed wealth.
I've been carrying it for labor.
No, he says nothing. It is unaccounted money. Then what? What have you done in that regard? What have you done? For the possession of this money, what have you held him guilty for? Under what provision of law?
That money is deposited.
Oh, have you made him liable under the Income Tax Act also? No. So then it is, as per you, it is not unaccounted money then. He can lay a claim on it. It's a fact. Yes, all right.
I take your lordship to PW 145.
PW 145 page.
Page is 680.
Volume 3.
That's in volume 3.
No, it's not. Well, I'm not having volume. Oh, this is it. Sorry. 680. PW
145.
Bikul Saikya.
Nicol Cycle lordship.
Yes, yes, yes.
On 1/4/2009, I was working as IC Jurabad Police Outpost. On that day, I was asked to investigate one case bearing 17009 of Vasistha PS. Prior to me, one Moizuddin Ahmed was investigating the case. Moizuddin, Mr. Ahmed handed over to me one Scorpio bearing registration number so and so, along with RC book and driving license of Bhojendra Hojai. One Tata Sumo bearing registration number AS01AL.
Who was the registered owner of the Scorpio?
Scorpio was Bhojendra Hojai lordship.
Registered owner. Registered owner of Scorpio.
RC in the name, oh sorry.
RC name.
No.
Name is not.
RC and driving.
Anyone has the
license of
information?
RC.
RC is there. No, RC has not been proved. All right, carry on. So these are the details given in. All right. Then
one American tourist briefcase containing documents, including 3 sheets of DHDJ pad, a letter written by Mohit Hojai, CM NC Hills, work order of NC Hills instructing to allot works to Bhojendra Hojai for 86 lakhs to 88 lakhs.
now here the Caesar and the link evidence becomes important, because All right, he has given out all details till 17. Now come to the next line on the page 681.
The above articles were handed over to me by Mr. M. Ahmed, and I have reseized the same.
Where is the reseizure memo?
I reseized it tonight. Reseized it.
It can't be done at the whims. Seizure was not physical. It is always through a document.
Yes, yes.
What is the exhibit?
I'll try to find it out.
Yes.
The cash money seized were deposited through challans after receiving order from CJM.
417. What is the page of exhibit 417, please? Can anyone tell us? Exhibit 417.
Yes, Lordship.
Volume 2, exhibited document.
417.
Yes, by that document, he has handed over the articles to NIA. Carry on, you keep on reading, please.
Yes, yes. I do, yeah. The cash money seized were deposited through challans after receiving the order from CJM. Accused Babul Kemprai and Pojendra Ojai were taken into police custody as per order of CJM during investigation. On the basis of facts disclosed by the aforesaid accused, I arrested R.H. Khan and Mohit Ojai. Thereafter, on 6/6/2009, Senior SP City Guwahati ordered me by so and so to hand over the case to NIA. And as per the above order, I handed over the same. By exhibit 417, I handed over articles mentioned in 417 to Santosh Kumar, Inspector NIA, on 8/6/2009. Exhibit 417(1) and 417(2) are my signatures. Today in court, I have seen the pistol, arm license, mobile handsets, letter pads of DSDJ, letter of Mohit Ojai, which were already exhibited in the court. 418 is the receipt memo by which I handed over the case diary of this case to Santosh Kumar. Santosh Kumar, NIA on so and so as per order of SSP. On 2/5/2009, I sent the seized arms and ammunition to the armorer. Armorer, 4th APPL, Guwahati for expert opinion. Exhibit 419 is the letter sent by me to the armorer, so and so. Now, the amount that has been seized, Lordship, it appears that has been deposited in the treasury, and Lordship, in the meantime, this demonetization that had come. Therefore, Lordship, this again had to be redone, and this is a part of the case diary, Lordship.
All right, all right. What do you want to say? They were deposited in the bank. They were deposited in the bank.
We did the counting, Lordship, before the treasury. That is
Counting.
and
But
counting, and
if
was-
this witness is to be believed, he says deposited through challans.
Lordship, that-
Challan is always a deposit in the account.
Yes, yes.
It's not a physical currency, doesn't remain there.
It's there, Lordship. It is, and what I was talking
So
about
where-
is, this is after the deposit. Then the
So once the money has been deposited,
Lordship.
where do you get the opportunity to count it?
Now, Lordship, as per the order of the Lanark Court.
You have this statement. Read 681.
Okay. this is the treasury.
It doesn't say. That's why I was on the memo. for it. 160.
Your card.
Hmm.
I'm sorry, Lordship, this money had to be again counted in the treasury, Lordship. A committee was set up. And thereafter it has to be again routed to the reserve bank. Lordship, this, if I may, this is a part of the,
Let us see, what is it? Yes, right.
yes, recount করলে আসবো। May I read it, Lordship? On receipt of compliance report submitted by Deputy SP NIA, Guwahati, this case record is put up today to deal with the rest of the prayers made by.
So, Mr. Chaudhary, before you read this, you tell us which of your witnesses says that in physical form the currency notes were kept. Who is your witness who says so? This is in 2017.
Lordship,
What was the fate of the currency in 2009? Where is the document to that effect?
the challan is.
So, as supposing he was under some misconception, where is that document of depositing the amount? Say physically, not a deposit in the account. Where is that document?
The challan I have not been able to locate, Lordship. But
Okay.
here, Lordship, if your Lordship will come to the second page,
Of,
second page of this document. Lordship, which is-
yes. The description is there, RC1, RC1, 1, 2, 3, 4, 5.
These pertain to the money seized in these cases, Lordship.
So items numbers 1, 2, 3, 4. They all pertain to RC1?
Lordship.
Why different dates? TR number.
Yeah, number.
3R of 18/8/2009 and one is of 10/11/2009. Why this 99 lakhs as a different date? Now, yes.
Yes, because
Why a different date? 10/11.
10/11, Lordship, yes.
These are all RC1.
These are all RC1, Lordship.
So, and the amount, if you count, that comes to almost 4 lakhs plus 5 lakhs, 9 plus 11, 20. So that is a 1 crore 20 lakhs.
Yes, Lordship.
How it increased?
So there were,
Gathered interest.
no, Lordship,
Then
there were other seizures also made.
RC1,
Yes, yes.
20 lakhs seized total. 1 crore 20 lakhs. There was one seizure of 4 lakhs more. So far as we can recollect,
My lord.
no other seizure, if we can recollect.
There are other seizures also.
All right, we'll see. But why this different date for 99 lakhs 95,000? Try ask your associates, work on this.
Yes, yes.
In the meantime, continue on this. Vipul Saikia is a very interesting question we'll put to you. Read the complete statement of Vipul Saikia, examination chief.
Yes, Lordship.
What does he hand over to the inspector NIA?
Thereafter, on 6/6/2009, Senior SP Guwahati ordered me by so and so dated to hand over the case to NIA. And as per the above order, I handed over the same. Exhibit 417. I handed over articles mentioned in Exhibit 417 to Santosh Kumar, Inspector NIA. Exhibit 417-1 and 417-2 are my signatures. Today in court, I have seen the pistol, arm license, mobile handset, letter pads of DSDJ, letter of Mohit Hojai, which were already exhibited in court. Exhibit 418 is my receipt memo by which I handed over the case to the case diary of this case to Santosh Kumar. Gosh.
Okay. So what did he hand over to the IEO of NIA?
417.
417, read 1652. We'll facilitate you. List. Were those 3 blank letterheads and the work order handed over to the NIA? He doesn't say orally, Mr. Chaudhary. He doesn't orally say that he handed over those articles. Now read from the list also. They could only have been referred to in case diary of 1/4/2009. Is it right? Because the seizure was of that day. The case diary of 1/4/2009 is at serial number 1. What has he given? Photocopy of search and seizure list, sketch map of place of occurrence. What happened to the documents? You peacefully read the entire list. If you can find it and let us know. Because he had reseized the documents on the same day on production. There is no access. Because like, yes, please. What was the fate of those documents? Has Santosh Kumar been examined?
Gosh.
Has he been?
Yes, Lord.
CW? CW? 148?
697. Okay. 697.
Yes.
May I read it, Lordship? I joined CBI.
Read his statement pertaining to 417. Other parts you can refer later.
Yes, yes.
417.
Page number 702. 702 page number.
70. Just hold on. Getting. What were the articles? Your receipt doesn't say that those documents were there. Bikul Saikya doesn't say, and Santosh Kumar doesn't say.
Doesn't.
Where were the documents proved from? Where did your prosecutor procure these documents from? These were the very only two witnesses who could have said about it.
Yes, Lordship.
Yes, let him say. Let him say. Yes, you want to give an explanation? Come. You say. What do you want to say? No. You hand over. All right. What is he giving?
It's not this one.
What is he saying? Read out. He's trying to give some explanation.
No, he's giving me the page number.
Page number. Which page number? 702.
Lordship.
Yes. We've read it.
697.
Yes, 697.
It's not
417 is at 702.
Yes, that I have seen. Lordship.
Some articles.
Some
What were those
yes.
articles, sir? And the proof of giving articles is 417. In that, there is no pertinent reference to the documents.
Lordship.
Yes. Next, what we'll read, sir?
So far as Lordship, vehicle and this seizure of the money, Lordship, those are the only things that I find on record.
Okay.
Insofar as Lordship, Kojendra ho jaye. I would again take your Lordship to PW 115. At page 605.
Sonam Lama.
Sonam.
He is that person.
That person. I is declared hostile. But I'll read it with paragraph 47 of the judgment. First, first the statement, then go to the judgment. I'm a graduate and used to write articles. I am an ASDC party worker. In 2009, I was also a party worker of the same party. I know Mohit Hojai. He was also in the same party. He became CM on 1st January 2009. Earlier to that, Dipolal Hojai was the CM. On 31st March 2009, I was staying at Guwahati in the flat of Mohit Hojai. The last sentence is, Lordship and Limak, on 31st March 2009, I was at Guwahati in the flat of Mohit Hojai. And this incident occurs on the
First April.
first.
So there's a 12 hours gap in that.
And he was declared hostile. And let me read the clause by the prosecution, Lordship. I was called by police once or twice, but I cannot say whether my statement was recorded or not. It is correct that Mohit Hojai had taken a rented flat at Megamallar, apartment Zuro Tiniali. I know Babul Kemprai. It is correct that I met him on 31st March 2009 in the aforesaid flat. On the evening, I was free. Hence, at the request of Babul Kemprai, we went to Ganesh Guri.
Yes, Karim.
It was about 3 or 4 p.m.
Yes.
There at Ganesh Guri, Babul Kemprai bought a ticket for a journey to Haflong by train. After that, I came back to my flat.
And his tire went flat. He doesn't support you after that. So he had a flat tire thereafter.
Lordship, let me finish this paragraph, then I will go.
Every answer he says it is not a fact. Every answer. Except for the fact that he came to know from TV news that they had been arrested.
Lordship will.
And above all, again, whether your prosecutor puts him a question, this is the Babul Kemprai you were there with.
Lordship, the first part in the cross. After that, I came back to my flat.
Bas, that's
You
it.
there?
Thereafter, it is not a fact. So what he says is Babul Kemprai met him on 31st. That's all.
Now,
So what do you want to draw from this?
because Babul Kemprai
Was present in Guwahati on 31st.
was
All right.
present in Guwahati.
He doesn't deny him.
And it comes from the evidence of the
Chandra Sharma.
Chandra Sharma vehicle went. Here
Ullu
Ganesh
Sonar,
Guri,
yes.
one person got in. Gosh.
Okay.
Now, paragraph 47 of the judgment.
Yes.
Uh, However, Lordship has got it. The Lordship
Yes.
is at page 35. However, this witness admitted that Mohit Hojai had taken a rented flat at Megamallar apartment, Zuro Tiniali. He knows Babul Kemprai and he met him on 31st March 2009 in the aforesaid flat. On the evening, he was free. Hence, at the request of Babul Kemprai, we went, they went to Ganesh Guri. It was 3-4 p.m. that there at Ganesh Guri, Babul Kemprai bought ticket for his journey to Haflong by train. After that, he came back to the flat. Now, at paragraph 49. In the case at hand, PW 115 has admitted having met accused Babul Kebra in the flat of Mohit Hujai on 31/3/2009. He also admitted having aware of the evening TV news that Babul Kebra and Bhojendra Hujai were arrested. Though he denied that Babul Kebra asked him to arrange for a vehicle to him to move around Ganesh Guwahati, and that he had arranged a Tata Sumo vehicle through Chandan Sharma, it should have been Chandra Sharma. Yet the said version is confirmed through the IO that
Now, this is a perverse finding for the reason that when you cross-examine this witness, these parts which he has denied, you did not tell him that this is your 161 statement. When you cross-examine, it is not a fact that on so and so I did so. That was a simple suggestion. Witness denied. You don't say that this was stated by you to the police. Assuming that even that defective confrontation is to be believed. In this statement, you did not even confront him with the previous statement. Because partly he admitted, but then when he went against you, your public prosecutor lost track and he forgot to confront. Look here, this is your statement, wherein you have stated so. So that's it.
only till the
He knew, all right. We go a step further, Mr. Chaudhary. Assuming Babul Kemprai was carrying 1 crore. What of that? What thereafter? That 1 crore was what? For what? Buying a flat in Shillong? Maybe. You don't know. He was proceeding towards Borapani. Shillong is
Supposed to
10
be
kilometers
delivered
away.
supposed to be delivered to some extent.
Oh, that was lost, left behind. Jorabat. Jorabat is before that.
Yes.
But they traveled further. They didn't meet any extremists on the way. They proceeded to Borapani. Next stop is Shillong. Maybe he wanted to throw it away on good 5-star hotels. Kind of evidence you are leading. You don't put a single question to both these two witnesses that you are saying a lie that this thing happened at Borapani. So that's an important thing again. Jorabat is left behind. How many kilometers behind is Jorabat? Between Guwahati to Jorabat.
Guwahati to Jorabat is around 12-13 kilometers.
So, but Borapani is about 60 kilometers. 10 kilometers before Shillong. So then they had left Jorabat long back, long behind. They were not interested either in armed smugglers or extremists. They wanted to use up the money. There is a very interesting feature. This escorting thing which I told you about.
Lordship, I did not know about. My friend says that that is the way that how it goes.
Yes.
I did not know about.
I'll tell you a very interesting thing. I shared with you that experience of escorting. No, there is one more important thing to it, other than the fact that they want that the police should, the vehicle carrying the goods should be kept away from the police and all. There is one more angle to it. These smugglers, they apprehend that the carrier might commit a breach of trust.
Oh, that is always.
That is also there. So this might have happened. They went ahead. क्या करना क्या देना 1 करोड़ बहुत है काम चल जाएगा अपना तो आगे चलो.
Yes, that is.
So that intention got lost in the meantime.
In fact, that did not click me. My friend says, no, it is always like this. But if I would have been on that side, alone is always better. Because 2 vehicles going, it is always a sight. Worship, he is saying next time, I will be engaged.
Since it has come from his mouth, so the next time I will look forever.
Because, Lordship, I have told your Lordship regarding my experience.
Yes, I-
My personal
You
experience.
know,
And it was really very devastating for me.
we have seen absolute blunders being committed in this case, which leave apart NIA. Your Maizuddin Ahmad was a seasoned police officer of the state. He doesn't know how to conduct investigation. So sorry, state. NIA, maybe the people had just started their business. But these people are seasoned people.
If I may be permitted, Lordship, in that Anupam Das. In fact, first thing in the morning, I saw some wounds in his hand. And it struck me like early in the morning, he's just come up from the bed. How? And when I informed the same to the police, they were after me. Why do you suspect it? And he told the police that he had liquor on the previous night, fell down, bottle break.
Ah,
And I said, that cannot be a class cut.
yes.
That much at least we know.
The resistance marks,
No, bite marks.
bite marks, yes,
Yes.
resistance, yes. That's right.
Was bite mark.
Tooth marks are very
Subsequently came
prominent.
out.
Teeth bite marks are very prominent.
And
They can't be missed.
And even later on, like when I had the information, because he walked out from here, another case was registered.
Hmm.
When I had informed the police that he is in so and so place. And they sent a constable with his photograph and luckily for us, after near
That
about 5 years.
That you narrated, yes. Okay, so next, what is the next argument which is coming forward? Sonam Lama is done. Next.
Sonam Lama is done, Lordship, Chandra Sharma is done.
Hmm.
Then George Lantham,
Yes,
PW 29.
he is your star witness. PW.
29.
Read, please.
That your Lordship will find on page 148.
Hmm.
May I read?
One moment.
Lordship.
He was not in custody when he made the deposition. He was not in custody when he made the deposition. George Lamthang.
He was in custody, madam.
Today I have appeared before the court on receipt of summons from court. How then this line? The note would have been he has been produced from custody.
No, when he came for giving deposition, my lord,
Yes.
at that time he was out. No, sir, it is likha hai.
CRPC.
No, he was in custody, madam. He was in custody.
That's why this question, note at top, would have appeared before the court on receipt of summons from court. So it could not have been. He must have been produced through a production warrant, not a summons.
No.
We presume that might be correct, but the recording is wrong. The recording on the statement is wrong.
It was a single man.
Yes.
Yes.
Lordship. I belong to Manipur. And since 2006, I have been settling in Kolkata along with my family, consisting of my wife, 2 children. Initially, I was working as a travel agent as well as a commission agent. Later on, I was also doing the job of money exchange on commission basis through money exchanger money changer, Topon in Kolkata. Since I was doing the job of procuring air ticket, I came to know who accused Valsakimi in January 2008. Since then, I used to facilitate travel tickets whenever she approached me for the same. One day, in April 2008, Valsakimi asked me whether I have any idea about conversion of Indian rupees to US dollars. At that time, I did not have any such contact and informed her that when I have contact, and something has been left out here now, and informed her that when I have contact. In June 2008, I came to know with Topon, who is a money changer, one day when I was sitting in a roadside tea shop near New Market area. I had two persons discussing about conversion of US dollars, and I got introduced myself to one of the persons whose name is Topon. We exchanged our telephone numbers, and since then, I used to contact him. In the month of August 2008, I informed Valsakimi that now I have got contact for conversion of rupees to US dollars. In the same month and year, Valsakimi brought rupees 15 lakhs from Aizol for conversion to US dollar. Then I contacted Topon and started conversion of rupee into US dollar with the help of Topon. It took about 3 days to complete the conversion. After completion of conversion, I kept my commission at the rate 15 paisa per US dollar and returned the converted money to Valsakimi. In this way, she normally used to bring 15 to 20 lakhs for conversion to US dollars from Aizol. In the month of October 2008, Valsakimi brought 20 lakhs for conversion to US dollars from Aizol. When I visit her hotel room at Center Point Hotel, Kolkata, to collect Indian rupees, on that occasion, I saw who accused Vallan Chana staying with Valsakimi at the hotel, but I did not know Vallan Chana. And Valsakimi introduced him to me as Vantia of Aizol. After collecting the money from Valsakimi, I left the hotel and went to my rented house with the money in Kolkata. Then I contacted Topon, and as before, I exchanged the money through Topon. It took 3-4 days to complete the conversion. In the same way, I kept my commission at the rate 15 paisa per US dollar and returned the converted money. In 2008, in November 2008, Valsakimi came to Kolkata and asked me to accompany her to Madhu Milan Hotel to collect the money of Vantia, Vallan Chana. And both of us went to Madhu Milan Hotel at Kolkata, from where Valsakimi collected rupees 1 crore from Phojendra. But at that time, I did not know Phojendra Hotel. After Valsakimi collected the money, both of us headed to my rented house at Kolkata, and from where we counted the money in detail and found it to be 1 crore. After Valsakimi left for our hotel and I started converting the money to US dollar with the help of Topon. It took about 10 days for converting the said money. After completion of conversion, I handed it over the US dollars to Valsakimi, and the same way I kept my commission. Again in 2009, Valsakimi came to Kolkata and asked me to accompany her to Madhu Milan Hotel in Kolkata, where she collected rupees 2 crores from Phojendra Hojai. At that time, I did not know Phojendra Hojai. After receiving the money, we both of us headed to my rented house at Kolkata, and from where we counted the money in detail and found it to be 2 crores. After that, Valsakimi left for her hotel and I started converting the money to US dollar with the help of Topon. It took about 20 days for converting the money. After completion of conversion, I handed it over. I handed over the US dollar to Malsakimi and in the same way kept my commission. Again in March 2009, Malsakimi came to Kolkata and asked me to accompany her to Shalimar Hotel at Kolkata, where she collected ₹1 crore from Phojendra Hojai. At that time, I did not know Phojendra Hojai. After receiving the money, we both of us headed to Center Point Hotel, Kolkata, where Malsakimi stayed, and we counted the money in detail and found it to be 1 crore. After that, I took the money to my rented house and started converting the money to US dollars with the help of Tapon. It took me around 10 days for converting the said money. After completion of the conversion, I handed it over the US dollars to Malsakimi, and the thing was same way I kept my commission. Although I was accompanying Malsakimi in the said 2 hotels, I did not have any knowledge about Phojendra Hojai, from whom Malsakimi collected the money on 3 occasions. Even Malsakimi did not have any knowledge about Phojendra Hojai. I learned from Malsakimi that she was collecting the money at the behest of Vallan Chand. I was simply accompanying Malsakimi when she said that she had money to be converted and she had to collect the money from a person in the hotel. In April 2009, May 2009, June 2009, July 2009, Malsakimi brought 15 lakhs from Aizawl for conversion into US dollars. On each occasion, I converted the money into US dollars through Tapon and in the same way kept my commission after conversion. I gave the US dollars to Malsakimi. I did not have any knowledge about her further transaction with the money. I was arrested on 11/8/2009 by Kolkata police.
Yes.
I was arrested on 11/8/2009 by Kolkata police, and the police seized 5 lakhs from my possession, which was given to me by Malsakimi on 7/8/2009. But she did not tell me what to do with the money, and she said that she will let me know what to do with the money. I admit that I had converted rupees to dollars, but I am not colleagues of any of the co-accused. I was only a commission agent, working only to get a little commission to be able to maintain my family. On 28/2009, I made a statement under 164 CRPC before Judicial Magistrate at Guwahati. Today, I have gone through the said statement, and I say that the same was recorded as per my statement. Exhibit 76 is my statement, is the said statement. Exhibit 76 of that. If I may take the exhibit, Lordship. Lordship.
Yes.
Lordship will find that at volume 2, page 502.
502. Volume 2. Exhibit.
Lordship. Exhibited documents.
Yes.
164 statement.
Yes, Lordship, that he says that Lordship will find the statement itself at page 507. From 502 to 504, Lordship is the formal thing. Handwritten, Lordship. I was born and brought up in the village Churachandpur district, Manipur. I read up to class 8. I married in the year 2005 at my village. For the future of my children, I shifted to Kolkata with family in the year 2006. In the month of January, a friend of my father is an order supplier at Aizol. His name is Lordship. I cannot read it. Used to purchase goods from Kolkata and distribute. Before leaving to Kolkata, I made contact with Lordship will come to the second paragraph of 506. So far as I remember, in the month of January 2008, a lady named Balsakimi called me over phone and asked me whether I do business in ticket. When I answered in the positive, she asked to help her in purchasing air tickets whenever she flies to Aizol. She called me from Kolkata. She asked me to meet her in the hotel. I met Balsakimi in the hotel. Thereafter, I, on few occasions, purchased air tickets for so-and-so. Balsakimi told me that she has got, I think it's shop in Aizol, and she used to purchase goods from Kolkata. After becoming familiar with each other, once in the month of April 2008, so far as I remember, Balsakimi asked me whether I can exchange rupees with US dollars. I told her that I can, and I told her that if I can, I will inform her. But presently, I have no such contact. Balsakimi asked me whether I have any idea about dollar. But I told her that I had no idea, and I informed her that I will inform her if I happen to get contact. On day.
Yes, all right. We have read that statement. What do you want?
So, Lordship.
This is a previous statement.
Yes,
what is its use?
In
this statement, he doesn't name Fosendra Ojai.
Lordship.
So, first time identification in court,
yes.
And he admits in cross, photo shown to me.
Yes. Lordship.
Then
yes.
What is the worth of the identification? So what is his link to the accused persons? Balsakimi, all right. Transactions in conversion. Important thing is, even after Fosendra Ojai was arrested, he continued to do transactions with Balsakimi. Oh, till July. Right? Fosendra Ojai was arrested in April. So his job and Balsakimi's job of converting dollars was not, even if we accept your case, not limited to Fosendra Ojai. It was a general work of converting money into dollars. How do you link it to the DSDJ? He doesn't utter a word DSDJ.
No, he doesn't.
So it's all right. At best, what you can say is that he helped Malsakemi in converting
Yes.
Indian currency to US dollars. And then there was one element called Tapan. What happened to him? He says he was arrested and then let go.
Yes.
Why should your agency not be asked a question of Malafites? Did the dollars work? Huh? Dollars were not only meant for procuring arms, they also were meant for buying freedom. Seems so. Why did you let Tapan go?
Lordship, he has not been.
Role of Malsakemi and Tapan in that manner. Same. Conversion. So why didn't you apprehend Tapan in this transaction?
He has not been brought.
Your IU doesn't even say
Yes.
that I made any interrogation. Maybe, all right, his role may be only to a money changer. But what was the investigation done from him? Because this is few occasions Malsakemi has used this guy. She may directly have contacted with Tapan. Why didn't your IU interrogate? Okay. In any event, what do you want to draw from this statement?
From his statement, Lordship. Only that, Lordship, Phojendra, money was collected from Phojendra for conversion. Now, how money has come to Phojendra, that the other witness.
Money was collected from Phojendra.
Phojendra.
How do you establish that? Who identifies Phojendra?
At that point,
You read 164.
yes, Lord.
One person, one person, one person. You could have got the test identification conducted. Why didn't you go for that? You have done a farcical exercise of photo identification by some people. Why not from this guy? He was your star witness. Why didn't you try him for that? So if his identification of Phojendra Ojai goes, what remains? Apart from the fact that the argument of exculpatory statement is there. So that is a little questionable. As a matter of fact, if you read the 164 statement, there was no need even to arraign him as an accused. Even in that statement, he simply says that he was doing this job. So he was in a way just like Tapan. So the NIA need not have made him an accused in the initial stage. He as well as Malsakemi, for that matter. They could have been witnesses. But assuming that is a statement, the criticism that it is an exculpatory statement of an approver. Ignore that. What does he prove? Taken as such. Malsakemi gave him money and he got it converted. All right. Maybe an offense under FERA, FEMA, Income Tax Act. How there is a link with the SDJ? Think on it. You've got 2 nights to work on it.
I'll try my best.
Rather 3.
I'll try my best.
Yes. Okay. And we expect that you will complete on Monday.
Yes, yes.
Yes. And what about the written submissions?
Will let him complete it, my lord.
Okay. He has got some aces up his sleeve. We apprehend.
No. I will try to give by Monday. I will give for Joel and Arvind, I will give.
Okay. What about you? You passed on the written submissions. He doesn't have any secrets up his sleeve. Okay, very well.
Lordship has given them